Hello, court master ma'am. Hello,
ಸರ್ ಹೇಳಿ ಸರ್.
it's madam audio ಕೇಳಿಸ್ತಾ ಇದೆ ಅಲ್ವಾ?
ಆಡಿಬಲ್ ಇದೆ ಸರ್.
Voice. Hello. ಮೇಡಮ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ನಮ್ದು?
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಮ್ಯಾಮ್. ಓಕೆ.
ಬಾಮ್ಮ ಇಲ್ಲಿ ಸಪ್ನಾ. ಇದೇನಾಯ್ತು ನೋಡಿ.
Don't misuse the 230. My lord, believe you and take it, no problem.
One matter.
Tomorrow idru kodi.
Well, tomorrow, my lord, day
My
before.
lord, one submission. My lord, I have filed. The matter is already disposed.
Where's
my
your
lord.
band?
My lord, I am parting person. My lord.
13%. Okay.
I'm coming from Bangalore, my lord. The matter is already disposed, my lord. I'm filed an application for withdrawal of amount, my lord. Kindly, it may be taken up tomorrow, my lord, along with fresh matters.
When do you want?
Tomorrow, my lord, along with fresh matters. My
All
lord.
right.
Please, my.
One connected matter day before.
Top of the list action.
My lords,
Matter.
my lords, on 12th, my lords, the matter was posted, that is a tax RES, my lords. 12th, it did not reach, my lord. So my lords have told to post it today and make a mention in the morning so that it can be taken up early, my lords. All the tax matters, tax RES matters.
Friday ge hakide alla.
Madam.
All tax matters for Friday antane
Alla, today it is posted, my lord. 3 post agide.
3 agideye.
3 agide, my lords.
ಯಾವುದು ಆಗಬೇಕು?
Madam, one, sir, adu agiddu I have given it to madam, like which case number anta. That may be posted at 2:30, it may be taken up at 2:30, my lords.
Your matter pertaining to child protection legal committee, my lord. One matter dispose ಮಾಡಿದ್ರಿ ತಾವು. Same matter, my lord, tomorrow. Junior board. Day before yesterday ಮಾಡಿದ್ರಿ.
Yes. Please. Continuous appointment.
Yes.
ಏನು ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ?
Members, my lord.
ಆಯ್ತು ಕೊಡಿ.
Nah, please. Madam.
Petrol. All right. Time. All right. ನಿಮಗೆ ಏನು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್? ಸರ್ಫೇಸ್ ಲಾಸ್ಟ್ ಇಯರ್ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದಾ? ಅದು ಇನ್ನೂ ಒಳ್ಳೇದಾ?
Covered matter.
230 ಬೇಕಲ್ಲ? ಕೊಡಿ.
It is covered, my dear. Busted and out.
ನಿಮಗೆ ಏನು ಕೇಳೋದೇ ಇಲ್ಲ ನಾನು.
Another matter, tomorrow. ಇಲ್ಲ.
ನಿಮಗೆ ನಾಳೆಗೆ ಬೇಕಾ ಕೊಡಿ, 230 ಬೇಕಾ ಕೊಡಿ.
ಇಲ್ಲ, ಇದು
ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಕೊಡಿ.
ಅರ್ಜೆನ್ಸಿ ಅಂದ್ರೆ ಲಾರ್ಡ್ಶಿಪ್ ಸೆಡ್ ಸೆಂಟ್ರಲ್ ಧಾಬಾ my lord 6 months ನಾಗ ತುಂಬ್ತೀನಿ ಅಂತ ಅಫಿಡೇವಿಟ್ ಹಾಕಂತ ಹೇಳಿದ್ರು ತಾವು. I have filed it tomorrow.
ನೀವು ಕೊಡಿ ಸರ್, ನಾನು ಎಷ್ಟು ಬೇಕಾದ್ರೆ ತಗೊಂತೀನಿ.
ಇಲ್ಲ, ಲಾಸ್ಟ್ ಡೇ ಬಿಫೋರ್ ಎಸ್ಟರ್ಡೇ
ಮೂವ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅರ್ಜೆನ್ಸಿ.
ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇದ್ದ ಮಾಡಿದ್ದೀನಿ, ಇದು ನಾಳೆಗೆ ಅಂತ.
I believe you and take it. ನಾನು ಏನು ಕೇಳಲಿಲ್ವಲ್ಲ.
I'm grateful.
Your lordship, election matters, all but 3 matters pertaining to the same society. Elections are done, your lordship. May I request?
ಪ್ರಪೋಸಲ್ ಕೊಡಿ.
Please, your lordship. May I request it on tomorrow's board?
Why 230 ಬೇಡವಾ?
A counsel from Bangalore is appearing, your lordship.
ಡಿಸ್ಪೋಸಲ್ ಮ್ಯಾಟರ್ಗೆ ಬೆಂಗಳೂರಿಂದ ಬರಬೇಕು.
It is his matter, your lordship. He has asked me to move it.
ಸರಿ, ನಾಳೆ ಕೊಡಿ.
Obliged.
One withdrawal, my lord.
Withdrawal.
109.
Which serial number?
109.
Thank you. Yes.
Please, always.
Submission note, serial number 141 is rendered infructuous.
Thank you. Learned counsel for the petitioner, 141, counsel for the petitioner submits, the petition is rendered infructuous due to efflux of time. The said submission is placed on record, disposed as having become infructuous.
Please.
Serial number 177, my lords. I filed impleading application, my lords. It's not been put up. If I may request it on Friday, my lords.
We'll see. But Kardak mat- Before I get up, I'll pass the one.
My lord, serial number 110, 2 weeks time will be granted. In,
10
please, 110,
Kardak ಹೇಳಿ sir.
please.
ಕೊಡ್ತೀನಿ ನೋಡಿ.
Please.
Serial number 1, fresh matters.
Sir, I am party in person, sir.
So-
Serial number 16, sir.
So,
Please place it before court hall number 4, sir. The matter was there, sir, before also, sir.
why court hall number 4?
Matter was
You
there,
can't
sir.
choose the court. ಎಲ್ಲಿರುತ್ತೆ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು. ಅದು ಕರ್ದಾಗ ನೋಡೋಣ. Yes.
Serial number 1, A.S. Patil, N.V. Aji.
For the petition. Ade, dismissal.
ಗೊತ್ತು. Where is he? ಏನ್ ಗ್ರೌಂಡ್ ಇದೆ ಮಲ್ಲಿಕಾರ್ಜುನ್?
Not,
ಅಕ್ವಿಟಲ್ ಇನ್ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬಿಟ್ರೆ
Millard, there was a letter written by the customer. The charge was,
that is your 1 over the customer. ಅದು ಕಷ್ಟ.
No, no.
Except acquittal.
yes. No, he himself, the allegation is, the amount is withdrawn from the account of the customer and it is debited, Millard, sir.
Did the customer give a letter prior to the issuance of charge sheet?
No, after the withdrawal,
After the enquiry?
no, during the course of inquiry. This was produced during the course of inquiry, page 57.
ಅದನ್ನ ಇಟ್ಕೊಂಡು
Letter, Millard, sir, it is dated 1/7/2011, page number 57.
Wash it on that ground. The only circumstance is ಅದು acquittal, not on benefit of doubt.
Yes,
Very difficult. Let's see if they are willing to compulsory retirement ಅನ್ನು ಮಾಡಿದ್ರೆ
please,
because of that letter. ಯಾಜಿ ಬರ್ಲಿ.
yes, please.
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
Serial number 2, Neem Shilvan, CBND.
Matter pertaining to allotment of petrol bunk.
ಅದೇ ಪೆಟ್ರೋಲಿಯಂ ಔಟ್ಲೆಟ್.
How this,
ಎಲ್ಲಿ ಯಾರು ಮಾಡ್ತಾರೆ? ನೀವೇನಾ?
they are, I only, my lords.
ಎಸ್ ಸರ್. ಹೇಳಿ.
So I issued LOI.
ಹಾ.
Subsequently, without allotting with the petrol bunk, they issue paper publication, that is annexure KK1, calling for fresh,
ಸ್ಟೇ ಆಗಿದೆಯಾ ಅದು?
pardon, my lords?
ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
No, my lords.
Stay ಇಲ್ಲ.
ಮತ್ತೆ ಏನೆಲ್ಲ ಆಗೋಗಿರುತ್ತೆ?
ಇಲ್ಲ ಆಗಿಲ್ಲ, ಏನೂ ಆಗಿಲ್ಲ. Nothing has happened, my lords. So what
But not,
they,
the first notification was issued in the year 2012. That is for the purpose of establishment of what is called as Kisan Seva Kendras. And the essential requirement is that the site offered by the candidate should not be abutting state highway or national highway.
Correct.
The copy of notification I produced at annexure R4.
All right.
It's very crystal clear, my lord. Then he was the solo applicant, petitioner
He was
here.
a sole applicant?
Solo applicant. And then he filed an application as per annexure R1, my lord. There, my lord, at column number 24, he says that there is a ownership transfer deed in his favor. And basing on those contents, my lord, in the first instance,
ಈಗ LOI was issued to him.
issued, my lord. LOI is condition.
You did not take it to its logical conclusion.
No, my lord.
What is the reason ಅಷ್ಟೇ?
My lord, what he has produced is as per annexure R1A, additional statement of objections are filed yesterday, my lord. It is-
Yesterday?
Yesterday, yes, my lord.
Why additional statement now?
Because what the document of title which he asserts to,
ಎಲ್ಲಿದೆ?
which has resulted, yesterday I filed, no? It has got attached.
ಬಂದಿದೆ ಮೇಡಮ್, additional statement of objection.
I
ನೋಡಿದ್ದೀರಾ?
received, my lords.
That is unregistered deed of relinquishment, which is not, it doesn't convey a legal title, my lord. So he never had the title to the property. That is on that score also he fails. And let apart the site
Now
that is
there
of,
are 3 categories. One, who has owned land.
yes, ma'am.
Second category, who has a leased land, valid lease. And the third category is leftover to be granted to those persons who are intending
Yes.
and produce documents that they are also going to buy, lease out a land. ಈಗ ಇವ್ರು ಯಾವ category ಬರ್ತಾರೆ?
Not, he firstly submitted that he has got exclusive rights over the property by virtue.
Exclusive rights by what method?
by virtue of Hakkubita Patra ಅಂತ ಹೇಳಿ he has
ಏನ್
produced.
ಪತ್ರ?
My father has executed a patra in my favor. It is a family property, my lords.
ಏನ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿದಾರ?
Gift deed ಇಲ್ಲ, ಹಾಕು ಬಿಟ್ಟ ಪತ್ರ ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಹ್ಮ್.
It is a family, they say that I have to obtain either a lease deed or a sale deed, my lords. It is my family property, I need not obtain lease deed or sale deed, my lords. It is my father who gives me the property by virtue of.
My lord,
Why are you worried? It's family property.
Lord, firstly, my lord, the site offered abuts
ಈಗ
state.
ಇವತ್ತಿಗೂ ಯಾರಿಗೂ ಅಲಾಟ್ ಆಗಿಲ್ವಾ?
He was the only one applicant. There are two aspects to be, my lord, it's not that corporation doesn't want to give, my lord, but
Give
then,
it to him.
my lord, but these rules are to be strictly adhered because site,
We will interpret the rules
Yeah.
only.
the site which is offered by the petitioner, it abuts state
6
highway.
ವರ್ಷದಿಂದ you are dodging the issue. ಅವರೊಬ್ಬರೇ ಅಪ್ಲಿಕೆಂಟ್ ಇರೋದು. What's the problem?
Lord, in fact, Lord, the
Rules
corporation,
ಪ್ರಕಾರನೇ ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾರೆ.
in fact, corporation
He
is,
would fit in completely in category A because it is the family property where you can take it as he owns the property. Category B and C ಹೋಗೋ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ ನಿಮಗೆ. Category 2 and 3.
my lord, but the relinquishment deed which he has produced, it is
What
not
relinquishment?
annexure R1A.
His father's rights are relinquished in his favor.
But it requires mandatory registration under section 17 of the Registration Act, my lord.
ಮಾಡ್ಕೊಡ್ತಾರೆ ಬಿಡಿ. ಅವರೊಬ್ಬರೇ ತಾನೇ ಅಪ್ಲಿಕೆಂಟ್. There is no rival
But
common.
all these eligibility criteria, they are required to be had and as on date of filing the application, my lord.
Sir, why did you issue LOI?
But it was conditional, like in the
That's what you have-
LOI.
See, you have issued LOI. Now he will comply with all the conditions. There is no other applicant now to that.
Yeah, but otherwise, my lord, the site that is offered should not be abutting state. It's not the intention of the corporation
If
not
it is
to
not
allot.
the intention, ಇಷ್ಟೊಂದು ಕೊಡ್ತಾ ಇದ್ರಿ ಎಲ್ಲ ತಗೊಂಡು correct.
My lord, even the instrumentalities of the state,
So the
they are
problem
bound.
is this mighty exuberance of being IOC. Nothing. Applicant ಕೊಡ್ಬೇಕು ಕೊಡ್ಲೇಬೇಕು ಅಷ್ಟೇ.
My lord, even the instrumentalities of the state, my lord, they are required to,
Instrumentality ಅಂತಾನೆ ಹೇಳಿದ್ ನಾನು.
they are required to abide by the rule of law, my lord.
ಎಲ್ಲದರಲ್ಲೂ ಮಾಡ್ತೀರಾ ಸರ್?
That Metro Rail
ಎಲ್ಲದರಲ್ಲೂ
Corporation
ಮಾಡ್ತೀರಾ?
case, my lord.
There are so many cases.
Yes, I do
For
concede,
me,
I do
where you
concede,
violated the rule of law.
I do concede, my lord.
Then if you concede, then you
Lord,
can't do this.
now, my lord, it becomes as a president, my lord. Hitherto, no such.
President ಇಲ್ಲ, president ಇಲ್ಲ. We'll pass orders.
And even,
PWD
my
has-
lord,
PWD has issued a letter, my
That
lord.
is the only circumstance. It's a family property.
my lord, even other site
ಏನು
that
ಬೇರೆ
is,
rival claimants ಇದಾರ ಫ್ಯಾಮಿಲಿಲಿ?
no, my lord, the site that is offered abuts state highway, my lord, because it is the rule.
That reason you may say, that's a different. thing.
The
Don't say that is, has no
the
land.
notification I have produced, my lord, that annexure
It-
R4.
ಎಲ್ಲಿದೆ?
It is a letter issued by the PWD to the corporation itself
ಏನಂತ?
that it doesn't abut to the highway, state highway. It is a local ಇದು municipality road ಅಂತ.
That's a subsequent document, my lord. Even if village limits gets converted to town limit, the
Road
designation
ಅಲ್ಲೇ
of the
ಇದೆ.
state
ಒಂದ್
highway
ನಿಮಿಷ.
remains the same.
1 minute sir. ಸೈಟ್ ಅಲ್ಲೇ ಇದೆ, ರೋಡ್ ಅಲ್ಲೇ ಇದೆ, ಎರಡು ಕಳ್ದೋಗಲ್ಲ ಆಯ್ತಾ? ಇವತ್ತಿಗೂ ಅಲ್ಲೇ ಇದೆ.
Lord, I have absolutely,
If PWD says it does not, it is a municipal road and not abutting the national highway, what's your problem?
Lord, it is of the year 2017, my lord.
You
Eligibility
want me to cause an inspection now?
My lord, as on, it may be at a later point of time, my lord, but as on the
That's
date of
why I'm telling.
notification,
A site maybe at the relevant point in time ಇರ್ಲಿಲ್ಲ, ಇವಾಗ ಅಬಟ್ ಆಗಿದೆ ಅಂತ. No, sir.
Lord, even otherwise on the ground
No,
of declaration.
The concern of the court is, why do you want to trouble a man who is eligible?
Lord, in fact,
And he is the only applicant. ಬೇರೆ ಯಾರ್ಗಾರು ಕೊಡೋಂಗಿದ್ರೆ?
yeah, Lord, in fact, the corporation would also be interested, but these things are the hindering
You
factors.
appear to be disinterested, corporation.
Lord, he has made a misdeclaration in the application form. On that score, my lord, there are 3 decisions already.
ಏನ್ ಮಾಡ್ತೀರಾ ಈಗ? You'll reconsider it? What?
Anyway, sought for mandamus will answer to that, my lord. Otherwise, it is contrary to the decision laid down by the Supreme Court of India. It amounts to a misdeclaration, my lord.
Facts.
Page number
There is
7.
no misdeclaration at all in this case. That I will hold.
My lord,
There is no misdeclaration, but there is misdirection from your part.
my lord, annexure R1 is the application form. The relevant clauses, I'll read, my lord. Regarding the ownership of the land at para number 24, he states ownership of the transfer deed submitted in favor of the applicant. And then
Let me see.
Page number-
We'll pass it over. 5 ಗಂಟೆಗೆ dictate ಮಾಡ್ತೀನಿ.
Please.
otherwise we'll consider their application pass requisite orders. No,
You are interested, very.
no,
ಸಾಯಂಕಾಲದವರೆಗೆ ಇರ್ತೀವಿ, ಎಲ್ಲಿ ಹೋಗ್ತೀರಾ?
no, I have matters till evening.
Then no problem comes. Yes. ಇವಾಗ it will hold up the list. Seal number?
Day before yesterday, my lordship dictated the matter with regarding to approval of the
Employment in another institution.
He's taken up permanent employment. Please.
Close. The petitioner is before this court seeking the following prayer. The counsel for the ನೀವು ಹಾಕಿದ್ದಲ್ಲ madam memo for disposal.
Petitioners are filed.
ನೀವೇ ಹಾಕಿದ್ದೀರಾ?
Yes.
please.
Who filed memo for disposal?
Petitioner, Your Lordship.
The petitioner, during the subsistence of the subject petition, has secured permanent employment in another educational institution. Therefore, the petitioner has preferred a memo seeking disposal of the petition on the aforesaid score, which is a subsequent event to the filing of the present petition. The document of such employment is also appended to the petition. Therefore, the petition is disposed as having become unnecessary. And quash ಮಾಡ್ಬೇಕು ಏನಿಲ್ವಲ್ಲ?
Quash annexure K, my lords.
Quash ಮಾಡ್ಬೇಕಾ ಬೈ?
Order passed by the please.
In the light of the petitioner securing employment elsewhere and the employment being permanent, the order of the first respondent, which is called in question in the subject petition as a matter of form, stands quashed.
Please.
So number 4. PM Mani,
Appearing to the petitioner, my lord, this matter of
I seek my lords, 2 days accommodation to file. Today I have received parallel remarks from respondent number 4. Please.
my lord, this is the 2021 matter, my lord, where regularization is denied, and on that score, the compassionate appointment has also been denied. I'm surprised, my lord,
I'll take this on Friday. There is Friday in fresh matters.
That's Monday.
Tomorrow I'm pronouncing 2 or 3 judgments.
That's Monday, my lords. I'll file a statement of
sir.
objections.
Nothing. Yes.
Monday, my lords. I request.
Friday fresh matters. Yes.
grateful, my lord.
Kindly pass over the matter, Your Lordship. The
First one,
statement.
delayed payment.
ಇಲ್ಲ
madam.
ಹೌದು the calculation is given by the department, Your Lordship. That is been ಅಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿರೋದಕ್ಕೂ ನಮ್ದಕ್ಕೂ ಸ್ವಲ್ಪ ಡಿಫರೆನ್ಸ್ ಡಿಫರೆನ್ಸ್
Yeah, other arrears also, my lords. Leave,
Pass
earned
over.
leave and
kindly
Pass over. ಏನಿಲ್ಲ ಅಲ್ಲ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಏನಿಲ್ಲ
institution. But leave encashment, my lord, they have to decide. But
ಕೊಟ್ಟಿಲ್ವಾ?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, earlier they were working in government college. Later, my lord, they were observed in the university. But that is there is a dispute whether university has to pay. In between, my lord, he has been suffering. Leave encashment ಕೊಟ್ಟಿಲ್ಲ, ಯಾರು ಕೊಡ್ತಾರೆ ಅಂತ, that has to be decided.
Joint and several direction point. Pass over.
for yes, Your Lordship. Kindly.
Number 6.
Huh? Yes, sir.
My lord, may I submit, my lordship?
Tell me what is your right.
Please, my lords. My lord, if
Now
I,
the IOC, your contract is over, everything is over. You are a sub lessee from the hands of the IOC, who was a lessee from the defense.
please, my lords.
Now that lease period is over.
Please, my lords.
ಅವ್ರದೇ ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ನಿಮ್ದೇನು?
3 submissions. But first, my dealership agreement in respect of this property is until 2030 and 2035 in the 2 petitions.
Between whom?
Between me and Indian Oil Corporation.
ಅಷ್ಟೇ. Defense is not involved in
Please.
it.
Second, so far as defense is concerned, I have 2 answers. First, my lords, defense has 2 communications. In one communication, defense says, I want to take back all the land. In second communication, defense says, IOC can keep the land provided they replace me with ex-servicemen.
Why? How is that?
I will show, my lords, that communication. Therefore, my respectful submission is their statement that we are taking back the land itself is untrue or is colorable. Third, they go before the Allahabad High Court and they say this policy decision to take back land is not final.
Where is that?
It's in my amendment application. Amendment application 1 of 2025. Both these communications are found.
Page.
Page 15. This is a letter from Indian Oil Corporation to the Defense Estates Officer. Your Lordship may please turn over leaf to page 16, the paragraph in bold.
In the instant case.
In the instant case, the subject site is operating as retail outlet on dealership basis, considering the decision taken by MOD for ensuring that retail outlets operating on defense land should henceforth be operated as company owned, company operated through ex-servicemen only. We'd like to inform that with regard to the subject site, we are prima facie agreeable to comply with this condition. That is, convert from current dealership retail outlet to a COCO.
One clarification.
Lots.
In every place where defense land is leased out like this, are they projecting COCO with ESM?
Lord, this document I got only through RTI. I don't know, which is why I have filed an application for directions, directing them to produce. They have still not produced what is true. Then, my lords, Allahabad High Court decision,
Page.
at page 26, my lords, annexure S. This is, my lords, a daily order. Para 7, your lordship may kindly see, my lords. At page 27. Shri so and so Deputy Solicitor General, on the other hand, has submitted that he may be permitted to seek instructions, especially with regard to the fact as to whether the policy of the ministry has attained finality or the matter is still under consideration. Lords, therefore, this
reply.
Lords, this is the daily order. So they must.
No, this. What is the reply of the DSGI there?
There is no further order thereafter. Thirdly, my lords, there is one more development. The government, and this also I have produced, my lords, in RTI documents. The government has now taken, at annexure R, has now taken a purported policy decision to give away all cantonment lands to the municipal administration. That your lordship will please find, my lords, in annexure R.
Page.
At page 23 is the, at page 24 is the document, 23 is the RTI application. 27 June 2024. As per para 2, your lordship may please see notes. As per the decision taken in the meeting, the broad guiding principles for excision of civil areas of cantonments and their merger with the adjoining state municipalities are as follows. The proprietary rights over all assets meant for providing civic amenities and municipal services in the excised area shall be transferred to the state government state municipality free of cost. Assets and liabilities of cantonment boards shall be transferred to state municipality. The municipal cover over the leased old grant properties in excised area shall be transferred to the state municipality.
What are you wanting to suggest?
Lord, therefore, my respectful submission is subsequent to this order, it looks like the union is taking a decision to hand over this entire area to the state municipality. Now, my lords, my respectful.
How does that solve your problem?
Lord, my respectful submission is the entire basis of the action of the union is no, we want to stop leasing of these areas to oil marketing companies or PSUs. Now, if they want to hand over the premises to a municipal corporation, let the municipal corporation decide as to what it should do with the land. Therefore, my lords, my respectful submission is let them not file an affidavit, both that is the union as well as the oil marketing corporation, as to one, whether they are standing by their policy or is their real policy to replace me by somebody else. Because annexure A, they say we want to take back the land. Whereas in RTI communications, I receive communications between them where they say they want to replace me with somebody else. That, my lords, is fraud on power. Thirdly, my lords, under the rules, this power is not there with the policy authority at all. It's
you enter into agreement with IOC that is up to 2030, is it?
Please, my lords. In one case, it is up to 2030, in another up to 2035. Annexure B.
That is a
Annexure D, my lords.
That's
and
a dealership agreement.
Dealership agreement in respect of.
That's correct. You have entered with dealership agreement.
Yes, sir. Since 1965 onwards, my lord, from time to time, it has been extended.
Okay.
Yes.
No problem.
And that has not been terminated.
Now, Union of India, 11 पे रखता है.
MB Convi sir is up.
Sir,
is total engaged total number.
File an affidavit, both of you. I'll pass an order.
Lord, one submission, Lord. Annexure B, my lord, in petition number 101240, my lord, for a moment may kindly peruse, my lord, because my financial interest is also affected.
Why, sir?
My lord, because we paid damages for the further extension of the lease period, my lord. Annexure B, page number 30.
Lease itto ilva 2030 35 over gaya.
My lord, lease got expired on
when, sir?
30th December 2021.
Lease with whom, sir?
Lease in fair of this respondent corporation.
Sir,
And
IOC lease with the defense expired when?
my lord, on 31/12/2021,
And how did you
Annexure
enter
B.
into, 1 minute, how did you enter into dealership agreement with these people up to 2030 and 35?
In anticipation that.
How
my lord,
did you
they-
enter
they would
into?
be- In anticipation that they were extending
So
since 19.
you have hoodwinked them.
My lord, since 1965,
Sir,
66.
whatever it is, if you knew that the lease is going to expire in 2021, how did you enter into an agreement with them up to 2030 or 35?
Yes, you,
This is abuse of power. Now, thinking that their lease will be up to 2035, they have set up their things there.
but now.
You knew it was 2021. See, they are not aware of the lease of yours with the defense. All right? You enter into a dealership agreement with them. Your defense with your lease with the defense is going to come to an end in
Lord,
2021, correct?
Lord, the corporation has made all endeavors. In the sense, the first order by the concerned authority under the Public Price Act that was passed in the year 2011, and thereafterwards an appeal was preferred before the district court. Then the appeal was dismissed.
2011, who filed?
The corporation. Then 2004,
Corporation against whom?
against the order passed under the KPP Act.
Correct, sir. Who initiated proceedings?
It is a defense, my lord, because the lease had got concluded. They issued show
Lease
cause
got
notice under.
terminated when?
My lord, in the first instance, it was in the year 2010. They didn't. We made a
When
application
did you
for.
enter into these dealership agreements? 2020, yeah.
2020 for 15 years up to 2025, the latest one.
How did you enter into that lease?
Not that.
2010 ನಲ್ಲಿ the lease was terminated.
Yes.
Proceedings are initiated under PPP.
Yes, my lord.
In
Then
Public Premises Act.
Yes,
You have suffered an order.
yes, my lord.
How did you enter into this lease?
Thereafterwards, I was before this honorable court in 3 writ petitions filed in the year 2000.
ಅದಾಯ್ತು, ಅದು dispose ಆಯ್ತು.
Then lease was extended. While extension of lease, my lord, we have paid up
It is true,
damages
sir.
of 39 lakh rupees.
Your right itself was shaky. Then how did you enter into these dealership agreements? For 15 years, in what anticipation?
No, that I'll look into, my lord, because
Look
that
into
ground,
what? Nothing.
that ground, my lord, that
Anu is
aspect I'll
right.
make. No, now, my lord, my submission is that this extension of lease, even during the pendency of the writ petition, was made up to 31/12/2021, subject to payment of damages which we have paid in a sum of rupees 39 lakh
That is
71,000.
between you and the
Defense, yes, ma'am.
All right.
Yes, ma'am.
Knowing full well that you had no right over the property, lease is not extended, it is terminated. How did you enter into a dealership agreement?
No, now, my lord, the corporation has made,
I'm
yes, my
asking,
lord, that I
asking
will.
a straight question, you're begging the question.
Yes.
How did you enter into a lease?
No, that aspect I'll have to seek instructions because
What
that was,
instructions?
even he is also aware of all these proceedings, my lord, that
All right,
it was, yes, my lord.
sir, he wants dealership, he has taken, why did you give it?
From the standpoint of corporation, all efforts were done and
For what?
finally they said, my lord, we are not going to extend. They called upon us to hand over the possession.
2010 terminated
Yes, ma'am.
lease. Proceedings for 10 years have gone on
Yes, ma'am.
and you enter into a lease with these people.
The-
Dealership agreement.
It was not, I mean,
So ಈಗ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಹೇಳಿದ್ರಲ್ಲ, ಎಲ್ಲ ಆನೆಸ್ಟ್ ಆಗಿ ಮಾಡ್ತೀವಿ. This is the honesty.
that aspect, my
This
lord,
is the IOC.
I'll go through the
Much-
terms of
Just
dealership
because it
agreement.
is IOC, you can't do whatever.
I'm not on with that approach, my lord, but the efforts and endeavors were made since they called upon the corporation to hand over the possession, and then we issued a notice as per Annexure C calling upon him to hand over the possession
Yes.
by 31/3/2022.
The petitioners in all these cases are different petroleum outlets.
Only two, my lord. In the first two petitions, the letter of communication issued by the corporation to hand over possession has been
ನಾನು
assailed.
ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಬೇಡಿ, ಏನು ಅಂತ ಈಗಲೇ ಹೇಳ್ಬೇಡಿ.
My lord, in the first two petitions, my lord, what is assailed is the letter, policy matter of defense, Annexure
ಒಂದು
A.
ನಿಮಿಷ. ಎಸ್ ಮನು, ಫಸ್ಟ್ ಅಲ್ಲಿ ಏನು?
First and second are both petitions where.
ಮೈಕ್ ತಗೊಳ್ಳಿ ನೀವೇ.
I'm sorry. First and second, my lords, are both petitions where there are two separate dealers who question the same annexure A and annexure B.
All right.
Annexure-
Petroleum outlets.
Please, my lords.
So 6.2 ಯಾರ್ದು?
Lords, 6.2 is another operator.
So you're all petroleum outlets only.
6.3 and 4 are questioning the proceedings under the Public Premises Act.
That's okay, that we'll see.
That's all. It's two petroleum operators.
Only defense point is only that we are don't having contract with the petitioner. We are contract with
You
the
are not
IOC.
concerned with the petitioner, you are
Yes.
concerned only with the IOC.
IOC, my lord.
That I am aware.
Okay.
Also, annexure C also has said, first two petitions.
The petitioners in 6.1 and 6.2 are petroleum outlets who have sprung to the said outlet on account of a dealership agreement entered into between the fourth respondent, the Indian Oil Corporation, hereinafter referred to as the corporation for short. The facts date back to a little walk in the history is necessary to be noticed. The land in which the Indian Oil Corporation claimed its right belonged to the defense. The defense land was sought to be leased in favor of the IOC on 21/6/2006. It transpires that the defense terminated the lease in the year 2010. After the termination of the lease, proceedings were instituted against the IOC invoking the provisions of the Public Premises Eviction of Unauthorized Occupants Act 1971. The IOC suffers an order at the hands of the concerned authority. There was a direction that the IOC should vacate the premises and IOC should hand over the vacant premises within a month. This is called in question by the IOC before the appellate court. Appeal comes to be dismissed. Up to 2020, the fourth respondent IOC has been fighting for retention of the land by initiating proceedings against the orders passed under the Public Premises Act. In the year 2020, notwithstanding the complete knowledge, the IOC enters into dealership agreements with petitioners in 6.1 and 6.2 numbers are
6 and 6.1.
6 and
6.1.
6 and 6.1. The dealership agreements were to be in subsistence up to 2030 or 2035 as the case would be. If the IOC itself was completely aware of the fact that the land in which they are wanting to enter into dealership agreements with the petitioners was itself in dispute as proceedings were instituted under the Public Premises Act against the IOC and they had suffered, it is ununderstandable as to how and what hope the IOC has generated in favor of the petitioners by entering into a lease for 15 years from 2020, 10 years and 15 years from 2020 as the case would be. Therefore, the action of the IOC in entering into dealership agreements, knowing full well of the aforesaid facts, suffers, prima facie suffers from want of bona fides. The learned counsel for the petitioner, Manu Kulkarni, takes this court through the application seeking amendment of the petition, to which he has appended certain documents. The learned counsel submits that the leasing of the defense land being withdrawn is not final and it is conditional. He would place reliance upon a communication from the defense, from the IOC, from the IOC to the defense, that the land they would not need, but it can be continued to be operated on COCO basis, but only to ex-servicemen. Therefore, it is not the case where the defense wants the land back or the IOC, the defense wants the land back. Since the agreement is subsisting between the petitioners and the IOC, it is for the IOC to steer clear the controversy. The controversy appears to lie now in a narrow compass as to whether the defense would want its land back or the land can be continued to be leased to IOC only to be run by ex-serviceman. So these things would require an affidavit both from the hands of the IOC as to whether IOC
Defense.
they would require an affidavit from the hands of the Union of India as to whether they would want the lands back as is now projected, or they are wanting to continue the lease with the IOC with specific condition that it should be operated on COCO basis and only through ex-servicemen. The affidavit shall also bear consideration of a communication dated 27 June 2024, where the defense wants to come out of all the civil areas in cantonments by excision or exiting from those properties. All these contents, all these should be borne in mind while the affidavit is filed by the defense before this court. 2 weeks. 2 weeks.
So I don't have any instruction from concerned department.
No, I am directing you, madam. I am
At least
not
3
asking you whether you will file.
At least 3 weeks too.
List the matter on 21st March at 2:30 PM for further hearing.
Please.
Please, madam.
Interim order may kindly be extended. Interim order granted.
Interim order subsisting will continue till the next date of hearing.
Great.
Bill number 7, Sunil Leslie Sai, MS Kiriama, KL Patil.
The university matter, Your Lordship, where the PhD
Will you KL
registration
Patil?
was cancelled.
Guide problem. Your guide has created the problem.
We had in
ಇವ್ರದ್ದೇನ್ ತಪ್ಪಿಲ್ಲ. ಗೈಡ್ ಪ್ರಾಬ್ಲಮ್ ಮಾಡಿದ್ದಕ್ಕೆ ಇವ್ರದ್ದೇನ್ ತಪ್ಪು. Yes. The petitioner is before this court calling in question a communication dated 31/1/2022 passed by the first respondent, by which the thesis submitted of the petitioner is declined to be accepted on the score that it has been submitted on account of delay. It has been submitted on delay. The heard so and so. Facts in brief germane are as follows. The respondent university comes up with a proposal for a PhD course, and the petitioner, finding himself eligible, gets registered for the PhD program as a full-time PhD candidate under the guidance of one Dr. so and so. This happens on 30/11/2017. The petitioner is said to have completed the PhD coursework within 1 year from the date of the provisional registration and submits his research proposal to the university through the research supervisor, the guide aforesaid. It transpires that the completion prerequisites and acceptance for proposal, the PhD registration gets confirmed. Therefore, the petitioner gets registered as a full-time PhD candidate on 10/1/2019 as the prerequisite or provisional registration gets confirmation. The petitioner, after the confirmation, is said to have submitted first half-yearly progress report on 5/7/2019 through the guide. And the same was continued from time to time at intermittent intervals. When things stood thus, a notice comes to be issued to the petitioner calling upon him to explain as to why the registration of the petitioner, PhD registration of the petitioner should not be cancelled for violating Rule 14.2 within bracket C and Rule 14.3. ಯಾವ rule ಅದು? Page. Where is Sunil Desai?
What's,
You know Dilva? Your rule? What is it? Which rule is that?
rule? Rule produce ಮಾಡಿಲ್ಲ.
Annexure ಮಾಡಿಲ್ವಾ?
ಮಾಡಿ.
ಕೊಡಿ.
14.3.
Of the regulations governing doctoral degree programs in the Karnataka University. The petitioner, on receipt of the aforesaid notice, submits a detailed reply denying the allegations of delay and the allegations of delay. The research supervisor or the guide issues a notice to the petitioner seeking explanation for violation of the aforesaid regulations. The petitioner again submits a representation that he has not received any information with regard to the delay, as the petitioner has more than 75% attendance. By the impugned order, the registration of the petitioner, the PhD registration of the petitioner stood cancelled, and therefore the petitioner is at the doors of this court. The learned counsel appearing for the petitioner would vehemently contend that the entire process that has led to registration of the PhD registration of the petitioner has taken place contrary to law. The learned counsel submits that it is the guide who has not informed or submitted the thesis that was submitted to him to the appropriate authority within time. Therefore, he would submit that with the finding. Therefore, he would submit that no fault can be laid with the petitioner, and the registration, PhD registration, could not have been cancelled on the said score. Per contra, counsel Sri K.L. Patil submits that action had to be taken in accordance with the guidelines, and the university was left with no choice, as the submission of the thesis has happened on delay, not once, but delay at intermittent intervals. Who is to be blamed is not the concern of the university. The papers do not reach the competent authority within the time. The result will be invocation of 14.2c and 14.3 of the regulations. He would seek dismissal of the petition. I have given my source. The learned counsel, the afore narrated facts are not in dispute. The events link in the, link in the chain of events and the dates require reiteration. On 30/11/2017, the petitioner registers himself provisionally under the guidance of one Dr. So-and-so for the PhD program as a full-time candidate. The communication of acceptance of the registration of the petitioner for PhD program reads as follows. Annexure A. Marked portion. The petitioner submits all the prerequisite for confirmed registration, which would be the study material. The communication of submission of study material reads as follows. Page annexure C. The progress report is also furnished at one instance by the petitioner through the research guide. The communication reads as follows. Page 18. When things stood thus, 2nd August. Scholarship the lab. When things stood thus, a notice comes to be issued to the petitioner on 19th January 2021, seeking explanation from the hands of the petitioner as to why, the PhD program to which the petitioner had got himself enrolled should not be cancelled on the score that the attendance of the petitioner fell below 75%. This is replied to. The notice reads as follows. Page Annexure K, page 34, 35. The petitioner replies to the said notice that he has attended regularly and submitted the progress reports at intermittent intervals through the proper channel, and there can be no question of shortage of attendance in the case at hand. The reply of the petitioner so submitted reads as follows, page 37, 35 to 37, sorry, 36 to 38. Notwithstanding the reply and not considering any content of the reply, the impugned order comes to be passed on 31st January 2022, cancelling the registration of the petitioner. The cancellation order reads as follows. What is invoked in the case at hand is clauses 14.2 and 14.3. The said clause reads as follows, 14.2, 14.3. The full-time candidates working under the guidance of recognized supervisors shall maintain their attendance at the place of research, and the attendance shall be countersigned by the guide and submitted to the university. The petitioner has appended plethora of documents to the petition. All the documents indicate the progress report submitted by the petitioner at intermittent intervals, and there is no indication by the guide or by the university till the notice comes about on 31/1/2021. On 19 January 2021, the order impugned in the case, order impugned at 31st January 2022 does not even consider all the documents that are appended to the reply submitted by the petitioner, on 28/1/2021. The petitioner claims that his attendance has been regular and never has been notified with shortage of attendance either by the guide or by the university. Therefore, the PhD program of the petitioner that he had got enrolled into and completed by the year 2021 cannot be taken away on the score that the petitioner has acted in violation of 14.2 or 14.3, as the case would be. The progress reports are appended. The progress reports were submitted to the guide. The progress reports have not reached the university from the hands of the guide. Therefore, no fault can be found of the petitioner for cancellation of the PhD that the petitioner had got himself enrolled in. In that light, I deem it appropriate to pass the following order. Allowed quashed mandamus issues to the respondents 1 and 2 to reconsider the reply of the petitioner submitted bearing in mind the observations made in the course of the order and pass necessary orders in accordance with law within 6 weeks from the date of registration of the copy of this order. Yes.
Number 8, A.L. Patil.
This is a matter.
My lord, can you leave it on next week, my lord?
Compulsory
Next week, my lord.
Increment.
Allah, order of compulsory retirement has been challenged.
Your statement of objection is ready, my lord.
Allah, this
File
is
it, my
third round of litigation before this honorable court. There are only two grounds on which I am urging, my lords. One is the inquiry, charge sheet is issued by the inquiry officer as well as the disciplinary authority, which could not have been done.
Sir, if disciplinary authority is himself the inquiry officer, you can't.
That has been delegated. Inquiry was delegated.
Page. Password.
File. Illa, ಸಿಕ್ತಿದ್ದಿಲ್ಲ file.
Password ಅಂದ್ರೆ 5
I'm sorry. Lordships may kindly see, inquiry was delegated by virtue of annexure
You
28.
enquiry report kodlilva?
Inquiry report kotru. Inquiry.
Where is the order appointing the inquiry officer?
Yes, my lords. Your lordships will get the order appointing.
Orders you give me. Order appointing the inquiry officer framing the charges and issuing the charge sheet.
Page 40 is the order appointing inquiry officer.
Page 40.
Page 40. ನಿಮ್ಮ ವಿರುದ್ಧ ಹೊರಡಿಸಲಾದ ದೋಷಾರೋಪಣ ಸತ್ಯ
ನಿಗಮದ
ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಧಾರವಾಡ ವಿಭಾಗ ಇವರನ್ನು ವಿಚಾರಣಾಧಿಕಾರಿ ನೇಮಿಸಿ ವಿಚಾರಣೆ ಮಾಡೋದು ಹೇಳಿದೆ. Now charge sheet your lordships will get at page 31, which is typed copy, or page 30, page 28, annexure C. ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಕರ್ನಾಟಕ ಅರಣ್ಯ ಅಭಿವೃದ್ಧಿ ನಿಗಮ ನಿಯಮಿತ ಧಾರವಾಡ.
Who is that?
He is the inquiry officer.
1 minute.
ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು.
ವಿಚಾರಣೆ ಆದೇಶದ ವಿಚಾರಣಾಧಿಕಾರಿ ವಿಚಾರಣೆಯನ್ನು ಯಾರನ್ನು ಮಾಡಿದ್ದಾರೆ? ಇಲ್ಲಿ ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು ಧಾರವಾಡ ವಿಭಾಗ ಇವರನ್ನು ವಿಚಾರಣಾಧಿಕಾರಿಯಾಗಿ ನೇಮಿಸಿ ವಿಚಾರಣೆ ಆದೇಶಿಸಲಾಗಿತ್ತು.
ಎಸ್.
ವಿಚಾರಣೆಯನ್ನು ನಡೆಸಿ ಸೋಣಿಸೋ ಪ್ರತಿಯನ್ನು ನಿಗಮದ ಈಗ ಯಾರದು?
ದಿಸ್ ಇಸ್ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕರು.
ಇದು ಸಹಾಯಕ ವಿಭಾಗೀಯ ವ್ಯವಸ್ಥಾಪಕ.
Disciplinary authority, your lordships will get ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಕರು. Managing director is the disciplinary authority who should have issued the charge sheet. He
issued the charge sheet.
The vibhagiya vyavasthapaka, the regional manager.
Vibhagiya vyavasthapakaru.
And his assistant is made the inquiry officer. And the second ground, my lords, is second show cause notice and the punishment notice proposing punishment, both are clubbed and given, which is in violation of. Your lordships will get the second show cause notice at page number page 52.
Page
52. Hello, sorry, one second. Page 52.
Notice ilide. ಅವ್ರ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಂಗೆ ನೀವು ಪೆಟಿಷನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, ಸೆಕೆಂಡ್ ಶೋ ಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. In the second show cause notice itself,
where is it?
Page 40 it starts, my lords. There is some confusion. ಅದರಲ್ಲೇ ಪೇಜ್ 40 ಅಲ್ಲಿ ಕೆಳಗೆ ಆದ್ದರಿಂದ ನಿಗಮ ಸೇವಾ ನಿಯಮ 46 ರಲ್ಲಿ ಹೇಳಿರುವಂತೆ
ಇದೆ ಕನ್ನಡ 48 ಯಾವುದು ಇಂಗ್ಲಿಷ್ ಡಾಕ್ಯುಮೆಂಟ್
40 ಪೇಜ್ 40 ದಲ್ಲಿ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. ಆದ್ದರಿಂದ ನಿಗಮ ಸೇವಾ ನಿಯಮ 46(6) ರಲ್ಲಿ ಹೇಳಿರುವಂತೆ ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರವು ನಿಮ್ಮನ್ನು ನಿಗಮದ ಕೆಲಸದಿಂದ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿಗೊಳಿಸಲು ಪ್ರಸ್ತಾಪಿಸಲಾಗಿದ್ದು
ಶಿಸ್ತು ಪ್ರಾಧಿಕಾರಗಳು ಕಾರ್ಯನಿರ್ವಾಹಕ ನಿರ್ದೇಶಕರು. He is the disciplinary authority.
Yes, he submitted an inquiry report. Inquiry report ಮೇಲೆ show cause notice, second show cause notice. ಈ second show cause notice ನಲ್ಲಿ they have proposed the punishment to me. That why should compulsory retirement not be imposed against you? These are the only two grounds, my lords, and I am supported by.
No, next week.
Please. My lord, statement of objection is ready, my lord. I will file it, my lord. Statement of objection, my lord.
Friday, fresh matters. ಅಷ್ಟೇ. ನಾಳೆ ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕಿ.
Please, Friday.
Heard the learned counsel appearing for the petitioner. The learned counsel for the petitioner projects twin illegality in the case at hand. It is the submission that the inquiry officer who is appointed is a rank junior to the disciplinary authority.
To the inquiry officer.
Disciplinary authority is ranked junior to the inquiry officer, and that has vitiated the proceedings. The other circumstance is that the second show cause notice also depicts the penalty that is to be imposed, and therefore the submission is what is given to the petitioner is a post-decisional hearing and not a pre-decisional hearing, as is required in law in terms of the judgment of the apex constitution and judgment of the apex court in the case of Karnataka versus ECIL AIR 1994 SC 1074. The learned counsel with the respondent seeks a day's accommodation to file statement of objections. List on Friday in the fresh matters list.
Ninth, Professor Chetan Manoli, please.
Compassionate. 2011 death, 14 years
Your Lordships,
247A.
Your Lordships, I'm on a different footing, Your Lordships. May I pass on this circular, government circular?
circular, madam?
Government circular, Your
Yenadu?
Lordships, wherein they say that,
What?
second page, may I take Your Lordships to the second? This is a circular wherein the government has given,
ನಿವೃತ್ತಿ ಹೊಂದಿರುವ ಪ್ರಕರಣಗಳು 2 ವರ್ಷ.
Your Lordships, may I take to page number 3 on the second page, Your Lordships?
right.
Para number 3 on second page.
All right.
Please, Your Lordships. ದಿನಾಂಕ 15/2/2012 ರಿಂದ ತಿದ್ದುಪಡಿ ಆಡಲಾದ
ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಅಲ್ವಾ?
ಪ್ಲೀಸ್.
ಎಸ್.
ಸೊ 247A ನಿಂದ ಅವಕಾಶ ಎಂದು ಈ ನಿಯಮಗಳ ಅನುಸಾರ
248A ಕೊಟ್ಟಿದಾರಲ್ಲ madam?
248A ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಆಸ್ ಪರ್ 247A, 2 years service they have given as per this circular to all the government employees, and the authority of giving.
Government employees, how did they enter?
Please, Your Lordships, I am coming to that.
How, direct recruitment after
Direct
the age of 30 years, you will get 2 years.
That is 247A, Your Lordships. This circular under 247A, they have given extra power delegated to the authorities concerned, principal secretary.
What purpose?
Please, Your Lordships.
For what purpose?
To give the benefit of 2 years of service, so that their pension amount to even the Dinuguli Naukarigu kuda ide. That's what I am reading, para number 3, Your Lordships. Page 2, para number 3, Your Lordships. Please. ದಿನಾಂಕ 15/2/2012 ರಿಂದ ತಿದ್ದುಪಡಿಯಾದ ನಿಯಮಗಳ 247A
ಹೊಂದಿದ ನೌಕರಿಗೆ ಅನ್ವಯ.
ಈ ನಿಯಮಗಳ ಸೌಲಭ್ಯವು ನೇರ ನೇಮಕಾತಿ.
Yes, madam.
Please, Your Lordship. As per rule, Your Lordship, daily
As per
wage.
rule, why did you issue this? Thodi.
Please, Your Lordship, rules will prevail, Your Lordship.
Take.
And not only that, they are regularized, they are giving this benefit to nearly 400 persons they have given this.
Alla,
Yes,
the
the
rule will
petitioner-
prevail, Your Lordship. The circulars to some particular.
ಈ ಕೊಟ್ಟಿರೋರಿಗೆಲ್ಲ ವಾಪಸ್ ತಗೊಂತೀರಾ? You take it back.
As per rule, Your Lordship, it cannot be.
Your Lordships, may I submit one more thing, Your Lordships? Annexure D.
One thing ಸಾಕಲ್ವಾ allow ಮಾಡಕ್ಕೆ?
Annexure D, I have already given a representation to implementation of this circular.
That will see the petitioners
Your Lordship.
are before this court calling in question an order, an endorsement dated 14/2/2022 by which the claim of the petitioners in terms of rule 247A of the Karnataka Civil Service Rules comes to be declined. They heard the learned counsel, Srimati Sunita P. Kalsur and the learned HCGP. ನೀವು ಯಾರಿಗೆ?
Respond number 1.
Facts in brief germane are as follows. The petitioners joined the services of the respondent corporation on daily wages in the year 1984 and complete 10 years of service in the year 1994. Owing to the completion of 10 years of service, the services of the petitioners come to be regularized on 11/5/1994. The petitioners have all attained the age of superannuation and retired at different dates. And today, all these petitioners are persons who have ceased to be in employment on account of their retirement on attaining the age of superannuation. The issue in the list is with regard to the entitlement of the petitioners for additional qualifying service for increase in pension. The petitioners represent to the respondent corporation to grant them 2 years benefit as is available under section 247A of the KCSR, which adds 2 years of qualifying service to these petitioners, 2 years to the qualifying service to these petitioners, so that the pension would go up would go up by a few notch, NOTCH. The petitioner, the representation comes to be rejected, rejection of which has driven the petitioner to this court in the subject petition. By the learned counsel appearing for the petitioner would seek to place reliance upon a circular issued seeking implementation of 247A even to the persons who have joined the service on daily wages and whose services have been regularized. Regularized. The learned HCGP would refute the submission contending that the rule entitles these petitioners addition to qualifying service only in terms of 248A and not 247A. It is our submission that 247A deals with direct recruitment and cannot become applicable to persons who have been regularized. She would seek dismissal of the petition. I have given my response. The afore narrated facts are not in dispute. The issue now lies in a narrow compass. The petitioner's entry into the services of the corporation on daily wages is in the year 1984. They are all regularized in their service on 11/5/1994 on completion of 10 years. The petitioners retire and are all now, petitioners retire on attaining the age of superannuation at different dates. After the retirement, they submit a representation. Annexure D, na?
Annexure D.
Page.
Please, Your Lordships.
Page.
Page 130. 130.
Submit a representation on 22/9/2021 contending that they are entitled to addition to qualifying service as obtaining under section 247A of the rules. The representation reads as follows, page 130, 131. This comes to be rejected by the impugned endorsement.
Annexure C.
Page
128.
This comes to be rejected by the impugned endorsement, holding that what the petitioners the endorsement reads as follows. What is the reason for rejection of the claim of the petitioners is that the petitioners are daily wage employees who have been regularized, and what they are entitled to is under 248A of the rules and not 247A. Therefore, it becomes germane to notice both the provisions of law. Rule 248A reads as follows. Rule 248A becomes applicable to those persons who were on contract basis or on work charge establishment in the services of the state, and when they are regularized, so addition or terminal benefit or addition or other benefits would be determined under the said rule. The other rule that is now become the fulcrum of the list is 247A. 247A reads as follows. 247A permits 2 years addition to qualifying service if an employee is recruited by way of direct recruitment beyond the age of 30 years, so that it would be beneficial for complete qualifying service to get full pension. The doubt whether Rule 247A would become applicable to employees who had been appointed on daily wages and regularized for the purpose of addition to qualifying service is steered clear by a circular issued by the government on 27/5/2019, in which, in 2019, the relevant portion of which reads as follows. Rule 247A is made applicable to even employees who had been appointed on daily wages initially and have been regularized in the services later. The petitioners fit into the clarification. Therefore, the denial of benefit under 247A to these petitioners is unsustainable. Unsustainable, and the endorsement that is issued rejecting the claim of the petitioners would follow suit of unsustainability. For the aforesaid reasons, the following order: allowed, quashed. The respondent state shall now reconsider.
Respond number 4, Your Lordship.
Respond number 4 shall now reconsider the claim of the petitioners and grant all benefits. Reconsider the claim of the petitioners, bearing in mind the observations made in the course of the order, and pass the necessary orders in accordance with law. within 3 months from the date of receipt of the copy of this order.
Please. Your lordships, I may permitted to file that circular along with memo, your lordships.
Please do that.
Please,
Let it be on record. ಯಾಕಂದ್ರೆ appeal ಹೋಗಬೇಕಾಗುತ್ತೆ.
please, please. I shall file.
Harshvardhan and Patil, PS Council.
Not seeking compassionate appointment of the
Why
petitioner.
do you issue circulars contrary to the rules, madam?
Kindly pass out. Senior is engaged court number 3.
ಯಾವುದು sir?
Seeking compassionate appointment, my lord.
Date of death, sir.
Date of death, my lord, 10/12/2000, sorry, 27/4/2011, my lord.
Anything else?
She was minor. Lord, there is a unreported judgment of.
Please, ಕೊಡಿ sir.
Which? Judgment. Wherein, my lord, the apex court has held that since the applicant was minor at the time of death of the employee on paragraph number 6 and 7, my lords. This girl was
mother ಇಬ್ರು
ಇದ್ರಲ್ಲೂ ಹಂಗೆ ಆಗಿದೆ.
ಹೌದಾ?
Mother was predeceased the father and she is now, my lord, alone. And immediately after attaining the age of 18 years, my lord, she has filed the application.
Amended regulation 5 will come in the way, my lord.
ಏನು?
But he died, my lord, in 2011.
Correct.
So before that, my lord, there was an amendment to the, my lord, regulation 5. The minor should attain the age of majority within a year, my lord, after the death.
ಗೊತ್ತು.
Then, my lord, she attained the age of majority after 9 years, my lord. 2019. 2019.
That is not in her control, sir.
Allah, that is the, my lord, law, my lord.
That is what Supreme Court has said in 2005.
Allah, idu
Interpreting this very provision. Just.
But I will look into, my lord, because as it is, my lord, our regulation stands, my lord, actually it is there.
ಅಷ್ಟೇ.
And Jammu and Kashmir, lordship, my lord, that also applies to, my lord, this case also.
ಯಾವುದು?
Jammu Kashmir, delay, my lord.
ಜಮ್ಮು ಕಾಶ್ಮೀರ.
Lord, Jammu Kashmir, my lord,
ಸಜತ್
2006.
ಅಹಮದ್ ಮೀರ್. Alright. ಅದು ಹಳೆ, ಅದು ಬೇಡ ಈಗ ಹೊಸದಿದೆ. 14 ವರ್ಷ ಏನ್ ಮಾಡಿದ್ರಿ? ಅಲ್ಲ, both parents are not there.
Both parents are not there.
Both parents are not there. ಅದನ್ನ ತಗೊಂಡೇನು ಮಾಡ್ಬೋದಾ ನೋಡಿ.
But the rule amended provision will come in the way, my lord.
Exceptional.
Says so.
But I will look into it.
I'll take it on Monday. Just on Monday in the fresh matter. ಇದೆಲ್ಲ ಕಂಪ್ಯಾಷನ್ ಅಷ್ಟೇ.
But since, my lord, she was aged only 9 years at the time of death, and even then she had made an application
But you
within 1
can't
month.
help, sir. We'll see.
Yes.
Yes, next.
Lapse of time, Lord.
Yes.
Right, my lord. In view of the Supreme Court judgment, that in Kerala Financial Corporation, that as per the Supreme Court guidelines, my lord,
yes,
sale
guidelines.
auction has not been conducted. The 30 days prior notice is to be given. May I pass on the judgment?
Notice issue ಮಾಡಿದ್ದೀರಾ?
I filed a compilation, my lord.
So,
ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದ್ದಾರೆ. Yes, yes.
Allala, I compel, the sale notice, my lord. Notice has not been issued to bring the property for auction notice.
Ask DRT.
In fact, my lord.
ಈಗೇನು ದುಡ್ಡು ಕಟ್ಟಿಲ್ವಾ ಇದು? ಏನು ಪೇ ಮಾಡಿ?
Auction ಮಾಡಿದೆ, my lord.
ಅಲ್ಲ, ಇಲ್ಲೇನೋ ಹೇಳಿದ್ನಲ್ಲ. Was sold on 7th auction.
Please, my lord.
Earlier, my lord, 62 lakh was fixed. Subsequently, they went on reducing the reserve price.
Can't help.
And without hearing the petition, my lord, as per that judgment.
Sir, every sale notice is notified.
In fact, my lord, as per Supreme Court judgment, 30 days notice to be given. That sale notice is without giving the notice, my lord, it was not heard.
Separate notice ಕೊಡ್ಬೇಕು ಫಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೇ.
Or 30 days notice ಕೊಡ್ಬೇಕಂತ.
30 days ಫಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೇ, ಆಮೇಲೆ 15 days ಅಷ್ಟೇ.
ಅಲ್ಲ, ಆಮೇಲೆ ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಫಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿಲ್ಲ.
ನೋಟಿಸೇ ಕೊಟ್ಟಿಲ್ಲ. That sale notice was issued, my lord. That sale notice was served on the petitioners.
DRT also is empowered to do all this. The petitioner is before this court seeking the following prayer. owing to the contentions, this court on 23/1/25 had passed the following order. Again, on a subsequent contention on 30th January 2025, the following order. The counsel Girish Ulmani appearing for, correct, Allah? Appearing for the respondent bank has now placed a memo appending to it all 7 sale notices notified and according to him were within the knowledge of the petitioner. Not a rupee has come about. The learned counsel seeks to project that the property of 62 lakhs is reduced and sold for a song. It became inevitable to the bank as no buyer came about for 7 consecutive auction notices, and in the 7th auction notice the price had to be reduced. No fault can be found. Prima facie no fault can be found, but however it is for the petitioner to approach the debt recovery tribunal and agitate all the grievances that he has projected in the subject petition before the DRT. Reserving such liberty, the petition stands disposed.
Recovery proceedings OS has been filed.
OS, huh?
OS is, that also is.
You know, OS
Recovery suit, my lords, for the due amount.
Next.
Number 12, Naveen GS. Girish
My lords,
Verma.
I appear for the petitioner, my lords.
73. Yes.
I have to file objections, my lords. I'm awaiting instructions. Interim order is already in operation, my lords. I'm awaiting, my lords, Parava's remarks.
On the period of limitation, it goes.
Next week, my lords, I'll file my objections, my lords.
As simple as. Notice is beyond limitation. 73.
I have to file my objections, my lords. I'm awaiting instructions. My lords may take it up next week, my lords. Before that, my lords, I'll file my objections.
Okay, I'll grant you time. List on 7th March for further hearing.
Please.
Objections, if any, by the respondents by then.
Please.
Great, my
Interim order subsisting.
My name may be deleted, my lords. Since Shuraj is appearing.
Girish Ulmani as appearing for the Union of India and retain the name of Shuraj Badode.
Please.
Great,
Next.
My lord, for the petitioner in this case, I have filed a. Sorry.
Interim order,
There is no interim order, my lord. All that I am asking is this rules, my lord, page 51. Lordships will see.
My lord, constitutional validity of the Electricity Amendment Act is
challenged.
Rules.
File objections. Please. The
Until then, my lord, the rules need not be given effect to is what I am praying.
Learned counsel MB Kanvi seeks 2 weeks time. Learned CGSC MB Kanvi seeks 2 weeks time to file statement of objections. List the matter on
after 2 weeks, any day.
List the matter on 6th March. Please.
The interim order may kindly be considered, my lord. Otherwise, they will take precipitative.
Yenadu.
Idralli cross subsidy is also challenged, and based on these rules, they claim
On
privileges.
that day, we will see if objections do not come about. We will see how can we stall the operation of the rules, sir.
Only I am saying precipitative action need not be taken.
have to be stopped.
Madam,
Brindavan, similar identical case allagiತ್ತು.
Entire ESCOM operations will be stopped.
No,
I am saying, Lord, the precipitative action need not be taken.
List
That's
on
all.
6th. Yes, list on 6th. The petitioner is at liberty to move the matter in the event any precipitative action is sought to be initiated against the petitioner.
Nothing.
They are
challenging the
liberty
license
to-
grant.
Challenging.
Your Lordship, I appear for the respondent, ESCOMs in this matter.
Yavadu?
Padmaja start Patri.
May I claim, Lord, let it be tagged with another petition. I'm so
With
sorry.
objection, Hakli, no, sir. Yes.
Tag ಮಾಡಿ.
Taga. Number kudi.
Yes, 100852.
This compassionate appointment, petitioner father died.
But ಇದರಲ್ಲಿ date ಎಲ್ಲ immediate ಆಗಿದೆ ಎಲ್ಲ.
Because
First time
immediately
ಬರ್ತಾರೆ.
mother has filed because the petitioner is the minor at the time.
It's coming up for the first time. Or notice ಆಗಿದೆ.
Notice, notice
Yes,
was-
madam.
Please, Your Lordship. The father of the petitioner died in the year 2010, Your Lordship. At that,
2010
please, Your Lordship.
Ah.
At that time, Your Lordship, the petitioner was minor, Your Lordship.
Same.
15 years old, Your Lordship.
ಇವತ್ತು ಕಾಮಟೆ ಅವ್ರದ್ದು ಆಯ್ತಲ್ಲ.
Please,
Lords, at that time, she is the minor. Therefore, mother has filed the representation. And even the principal of the institution as well as the DDP of this,
All of them
district
have
has-
compassion. So recommend
They
ಮಾಡಿ.
have recommended, my lords. She has made a representation since after the death of the father, my lord.
When did you attain majority?
In the year 2015, once again, I attained a majority, my lords. My mother has made a
Anyway, that
representation at Annexure C, my lords.
latest judgment Supreme Court ಈಗ ಕೊಟ್ರಲ್ಲ ಅದನ್ನ ಅದು ಯಾವತ್ತು ಹಾಕಿದೆ ನಾಡಿದ್ದಲ್ಲ
Please, Your Lordship, yeah.
Friday or Monday.
Monday,
List on Monday in the fresh matters list.
please,
ಅದನ್ನ follow ಮಾಡಿ we'll do something. We'll see.
please.
And at the time of death of the petitioner's father, Your Lordship, his services were not regularized, Your Lordship, moreover.
ಅದು ಇಂದಿದೆಯಾ?
But thereafter, the petitioner's mother filed a writ petitions and it was regularized after
Later
SLP
on-
was dismissed.
ಆಗಿದೆಯಾ?
Later,
Ah,
later.
Then the pension was settled. Thereafter, again, once again, the
They will
representation.
dispose it.
Please,
Monday fresh matters list.
please.
Number 15, CA Kulkarni.
Yes, sir.
Respondent for in this matter.
Ah,
I request my lords a week and finally to lords file objections, my lords. Kulkarni sir is in line.
yes, sir. What's the matter?
Millards, I came to be appointed in this WIMS Act as an assistant professor on 1/2/2008 and came to be promoted as a associate professor on 6/8/2012. That promotion is challenged by respondent number 4 on the ground that she had joined the WIMS earlier than me as assistant professor. The MCI guidelines following, I was extended the promotion because I worked there prior to joining this Bellary in Andhra from 26/6/2006 to 31/1/2008. That service teaching experience was counted by MCI guidelines according to the MCI guidelines, and I came to be promoted on 6/8/2012 associate professor. My promotion was upheld by this court in the challenge made by respondent number 4 in the earlier writ proceedings. But seniority issue was kept open and that has to be decided was the direction issue. She also came to be promoted as a first professor on 15/7/2013, my lords. I came to be promoted to that grade in 2012.
Now, what is the outcome of the order? Outcome of the order passed on 19th April 2018 by the coordinate bench?
Millards, actually speaking, they took a decision that because the MCI guidelines followed and promotion is given to me is in order. Therefore, they left the case of the respondent number 4. They dropped the case actually.
Now, what is the problem?
Now, what they have done is my promotion date is as professor to the next grade, from assistant professor to associate professor to the professor.
Yes.
That has been on 24/1/2024. I have been extended, and she has also been extended on 24/1/2024 only. Now, in the professor grade, seniority issue is cropped up, and that's what they are keeping it alive.
Yes, sir.
I appear for respondent number 4, my lords.
Require your objections.
Please.
Finally, I'll grant you a week's time.
Oblige.
The counsel for the heard the learned counsel P.A. Kulkarni appearing for the petitioner. The prayers that are sought and the contentions that are advanced would require statement of objections from the hands of the respondent. Which respondent?
I appear for respondent number 4.
And also the WIMS.
From the respondents. Therefore, finally, 10 days time is granted to file statement of objections. List the matter on 13th March. Objections, if any, by any, by then. Yes.
Oblige.
Number 16, 13%.
ಯಾಕೆ ಆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕು?
Service matter, they have sought
Service matter.
she has sought the details of the her husband's ex-husband's service details, my lords.
No, you said it should go to court hall 4. Why?
Sir, the matter was posted there only, sir. I had taken time,
In
so
the
I
earlier
thought
roster,
of
that service matter was
ಯಾವತ್ತಾಗಿತ್ತು? ಅಲ್ಲಿ ಬಂದಿತ್ತ?
earlier roster.
So it was posted today, so I asked there, sir.
Sitting ಇರ್ಲಿಲ್ಲ. Let's.
For that judge, it was.
ಸೂರಜ್ ಸಾಹೇಬ್ ಮುಂದೆ ಯಾವಾಗಲೂ ಬಂದೇ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ ಸಿಟ್ಟಿಂಗ್ ಇರ್ಲಿಲ್ಲ ಕೋರ್ಟ್ ಹಾಲ್ 6 ಹಂಗಾಗಿ ಅಲ್ಲಿ ಬಂದಿತ್ತು.
Anyway, we'll list it on 3rd March. List on 3rd March. Yes.
Please.
Next.
Let's the other counsel who is appearing for respondent number 2, my lords, his name may be deleted.
Whose name? They registered to delete the name of TM Nadaf from the cause list and retain the name of Gayatri SR for the second respondent.
Great.
17 Hanumanti Reddy Sauka.
Let's may I request serial number 17 on Tuesday, my lords, will file objections. Objections are ready.
Tuesday, but 4th March.
Please.
Objections, if any, by then. Next.
Please.
My lord, my lord,
Avinashi Mangdi.
my lord, in serial number 17 in the connected matter, instead of A. Patan for R4 to R6, MM Khanur may be taken on record, my lord.
The registry 17.1 registry to delete the name of A. Patan as appearing for R4 to R6 and print the name of MM Kannur
Please, my lord.
as appearing for R4 to R6. Yes. Connected with 17.1.
Number 80 Avinashi Mangdi.
Lord, the offense is under 376(2)(n), my lord. Promise to marry.
Respondent illala. Served. Yavag serve agide nodi.
Name wrong.
25 days.
25 days.
January 5th ಗೆ ಸರ್ವ್ ಆಗಿದೆ.
ಒಂದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಕೊಟ್ಟಿದ್ದೀರಿ.
ಒಂದು ಚಾನ್ಸ್ ಕೊಡು. ನನ್ನ ಹತ್ರನೇ ಇರ್ಬೇಕು ಹೆಂಗೋ ಇದು.
Please.
Yes, list the matter on 14th, awaiting the appearance of the awaiting representation or appearance of the complainant as she is served on 5th January 2025. Interim order subsisting will continue till the next date of
Obliged.
yes.
Number 19 Prashant Bhatpati CV Angdi.
My lords, appearing for petitioner, my lords. Kindly request that the matter might be had tomorrow, my lords.
So my objection is with regard to very maintainability of the petition.
Correct, nennedala idu.
Yes, it was a posted day for yesterday, my lords. Here, my lord, because of the PESO license being cancelled in view of the expiry of lease, my lord, this particular letter was issued by the corporation as per Annexure A, which has been assailed, my lord. In fact, with regard
List on 4th March, interim order subsisting will continue to the next date of hearing. Objections,
Lords.
if any, by then.
Tomorrow, my lords.
My impleading application, my lords. At least if I lordship, so please to allow my impleading application. If I may be permitted to come out. Please, please, please. Obliged.
Number 20 Sen Rajendra.
Hearing for the petitioner. Lord, 15 years time bond scale benefit was given in the year 1994, my lord. And after his retirement, my lord, in the year 2012, my lord, that scale has been withdrawn without issuing any notice and without giving any opportunity.
Yes,
It's covered by.
Only point, my lords, that I would like to urge is, my lords, delay, my lords. Kindly see, my lords, he has attended his
Delay ಯಾವ್ದಕ್ಕೆ sir? Delay ಏನಕ್ಕೆ sir?
Andre, he has attained his age of superannuation, my lords, on 31/9/2012. And my lords, he has- 2012, and he has filed this petition, my lords, in the year 2024. And the impugned order, my lords, was passed on 21/7/2012.
21/7/2012
is the date of impugned order. And my lords, he attained the age of superannuation and retired on 31/9/2012.
Pension payment order.
Yes. Then, my lords, the writ petition is filed in the year 2024. That is
Recovery ಮಾಡಿದ್ರಾ?
Recovery ಮಾಡಿದ್ದಾರೆ 1,19,000 and odd. It was done, my lord, without issuing notice and without.
Scale was withdrawn without notice.
Yes, without notice.
My lords, time bound scale, my lords, was given to many of them.
ಕೊಟ್ಟಿದ್ರಿ ತಾನೆ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಉತ್ತರ ಮಾಡ್ಬೇಕಾದ್ರೆ notice ಕೊಡ್ಬೇಕು.
That aspect of the matter.
ಬರಲ್ಲ, ಡಿಲೇಗೆ ಅರಿಯರ್ಸ್ ಏನಿಲ್ವಲ್ಲ.
ಇಂಟ್ರೆಸ್ಟ್ ಕೇಳ್ತಾರೆ.
3 ವರ್ಷ ಅಂತ. ತಸ್ಲೀಂ ಸಿಂಗ್ 3 years.
3 years interest.
3 years prior to the date of filing of the petition, no arrears.
At the time of admission, I have given the copy of the.
Which one?
My lord, Taslim Singh judgment.
2008.
Yes, ma'am.
They are not entitled for any interest anta mani.
Interest illa. You can't sit quiet and claim interest also. Arrears kodi.
And refixation of the pension has to be done.
That also should be done. The petitioner is before this court calling in question an order dated 21/7/2012 by which the time-bound scale that was granted to the petitioner on completion of 15 years of service is withdrawn, and consequential changes in the pension has been effected too. Heard so and so. Facts in brief, Germain, are as follows. ಯಾವಾಗ ನೀವು ಸೇರಿದ್ದು
Petitioner was appointed on.
Petitioner is appointed on 9/10/1972 as a NACA officer in the Octroi department on temporary basis. Later it transpires that the service of the petitioner comes to be regularized. The issue in the list is not with regard to the service rendered by the petitioner, but the during the service of the petitioner, during the service of the petitioner, the government notifies Karnataka Civil Services automatic grant of special promotion to senior scale of pay, rules 1991. The petitioner was extended the benefit in terms of the rules. 15 years ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದು ನಿಮ್ಗೆ ಅವಾಗಲೇನಾ?
ನಮ್ಗೆ ಅವಾಗೆ ಮುಗ್ದಿದ್ದು 74.
On 2/12/1994. On 10/10/2000 it transpires that the respondent corporation extended the said benefit to all employees including the petitioner. Owing to certain audit objections on 21/7/2012, long after the grant of the said time-bound scale, the said scale comes to be withdrawn. The withdrawal resulted in a short payment in pension. The petitioner did not challenge the same immediately, but has approached this court after submitting a representation on 18/5/2023 and 6/3/2024. The representations were not considered, therefore the petitioner is at the doors of this court. The learned counsel appearing for the petitioner submits that the time-bound scale that was granted to the petitioner in the year 2000 is sought to be withdrawn in the year 2012 without even issuing a notice to him. And the learned counsel further submits that the pension has been short paid, and the recovery of
1,19,000.
1,19,000 is affected from the terminal benefits of the petitioner. He would therefore seek quashment of those orders and the release of terminal benefits in its entirety. The learned counsel Gurudev Gachinmat appearing for the respondent corporation would submit that the orders challenged are of the year 2012. The petition is preferred in the year 2024, 12 years thereafter. The petitioner has kept quiet for 12 years and knocked at the doors now. Therefore, even if he is to succeed in the petition, he should not be awarded any interest or as claimed.
Therefore, he is not entitled for any relief.
In the light of the delay in approach, the counsel would submit that he is not entitled to any relief that he has sought for, as delay defeats equity. Is his emphatic submission. I have given my sounds. Therefore, narrated facts are not in dispute. The issue now lies in a narrow compass. ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಿಲ್ಲ document?
ಮಿಲಾಡ್ ಕೊಟ್ಟಿದ್ದು annexure B. Page, my lord, in page 24. 24, my lord. 23 is the Xerox copy. 24 is the typed copy, my lord.
The petitioner was granted time-bound scale in terms of the aforesaid rules. ಯಾವತ್ತು ಕೊಟ್ಟಿದ್ದು ನಿಮಗಿದು?
My lord, on 2/12/1994.
On 2/12/1994, the said document which depicts such grant reads as follows, page 24, marked portion. The petitioner did enjoy the said benefit, and the salary of the petitioner was reworked in accordance with the said benefit. It transpires that at the time of retirement of the petitioner, there arose an audit objection with regard to the grant of time-bound scale to the petitioner. It was said that he was not eligible for the said time-bound scale. Therefore, the time-bound scale that was granted in the year 1994 as continued in the year 2000 comes to be withdrawn by an order dated
in annexure E.
By order date 21/7/2012. This is admittedly without issuance of any notice to the petitioner. The issue now would be whether a benefit that is granted in the year 1994 could have been withdrawn on 21/7/2012 on the eve of retirement of the petitioner. The issue need not detain this court for long or delve deep into the matter. The apex court in the case of Rafiq versus so-and-so whitewashing.
State of Punjab versus Rafiq.
State of Punjab versus Rafiq 2015, 4 SCC page 554, 334, para 18 extract money. The apex court lays postulates of recovery of amounts that have been erroneously paid in the past. All the postulates that are there, that are laid down by the apex court would become applicable to the case at hand. The benefit that was granted in the year 1994 is sought to be withdrawn in the year 2012, that too without issuing any notice to the petitioner. Therefore, the said action of withdrawal of the time-bound scale becomes unsustainable. The issue now would be whether the petitioner's time-bound scale. The result of holding of the withdrawal of the time-bound scale being illegal would be that the petitioner would become entitled to all the arrears of pension from 2012 till the date of its payment. The date of its payment. Interest ಕೊಡ್ಬೇಕಲ್ಲ ಮತ್ತೆ.
He has not approached in time.
ಅದು 3 years ತೆಗಿಬಹುದು.
Interest he may not be entitled. Because
arrears ತಗೊಳ್ಳಿ, interest ಬೇಡ.
Please.
The petitioner shall thus become entitled to the arrears of pension in its entirety to be calculated and paid from 21/7/2012 till the date of payment. In the normal circumstance, this court would have awarded interest. The petitioner has not approached this court immediately. For an action that happens on 21/7/2012, petition is preferred 12 years thereafter. The petition would be dismissed if the procedure had been followed by the respondent in withdrawing the benefit. Since it is not and it runs foul of the judgment of the apex court, I have entertained the petition and granted the aforesaid relief, but without interest. For the aforesaid reasons, following order. Allowed, quashed. The petition.
Deducted amount has to be. Deducted amount has to be returned.
So and so. The allowed, quashed. The amount that is deducted or recovered from the terminal benefits of the petitioner shall be refunded to the petitioner. Refunded to the petitioner within 4 weeks from the date of receipt of the copy of the order. The pension of the petitioner shall be reworked and arrears of pension from 21/7/2012. Retire ಆಗಿದ್ಯಾವ ನೀವು?
31/9/2012.
From 31/9/2012 till the date of payment shall be complied with. 4 weeks. Shall be complied with in the next 8 weeks. 4 weeks, adu 8 ಮಾಡ್ಬಿಡಿ first. 2 8 ಇರಲಿ.
Please.
Next. Order according.
Grateful.
From the date of receipt of the copy of it.
Date of receipt.
Please.
Number 21, Rajendra R. Patil.
Sir, in challenging the endorsement, my lord, this is under Motor Vehicles Taxation Act, my lord. The explanation too has been, my lord, brought by way of amendment.
First.
Let's notice, my lord, already government.
ಎಲ್ಲಾಗಿದೆ?
Government notice is directed, my lord, to the government advocate.
Where? Oh, Leonard AG is directed to accept. Yes, sir.
It's covered, my lord.
Kodi.
Along with, my lord, the petition itself, my lord.
Page.
Annexure D, my lord.
D. Yes, government will close it.
So only, please, my lord, ನೋಡಿದ್ದೀನಿ. ಅದರಲ್ಲಿ, my lord, as per the order of the Honorable Apex Court, my lord, there has to be 2 conditions. My lord, the pendency of the appeal and, my lord, the
page number 193, my lord. That's the interim order.
With that observation, my lord.
Interim order ಇದೆಯಾ?
Please, my lord. In the Apex Court, my lord, it has not stayed, my lord, the judgment of this honorable court, but granted interim order.
Then we granted an interim order now. ಇಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಬೇಕು ಮಾಡಿ.
Close ಮಾಡಬಹುದು. Subject to that riding clause, my lord.
Subject to the result of that appeal, it may be closed, my lord. May I read, my lord, the interim order what state? page 193.
ಒಂದು ನಿಮಿಷ ಇದೆಲ್ಲ ಪೂರ್ತಿ ಓದಕ್ಕಾಗಲ್ಲ. ಇದು ಕಂಟೆಂಪ್ಟ್ ಆಯ್ತು. ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ಫ್ರೈಡೆ ತಗೊಂತೀವಿ. ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ in fresh matters.
Please.
22, Surabhi Kulkarni, Saurabh Sandhu.
This is a matter where, my lords, on the last occasion.
Petitioner is an auction purchaser, my lords.
Registration.
I'm appearing on behalf of respondent number 9. In this case, my lord, I produced the additional document. In this case, my lord, the respondent.
Revision petition.
Yes, we have filed the revision petition before the minister. My lord. In this case, in 2012, the respondent number 3 to 5, and the name of respondent number 6, they had paid the around more than 40 lakhs rupees. After I purchased this property.
That is between you and him.
Yes, my lord. They
What
purchased
is
the
the auction
property.
purchaser do?
My lord, thereafter I challenged that order, my lord. Before this court also challenged.
ಎಲ್ಲಿದೆ ಅದೆಲ್ಲ?
That is the produce. I will
Once
produce the
available,
document, my lord.
With my IA seeking permission, I filed the copy of writ petition. Your lordships may kindly.
List on 3rd
Alla,
March.
one submission. my lords.
Objections if any by then. Next.
They've already filed.
Sir, already filed.
They've already filed.
They have filed objection.
We'll hear it on 3rd. Yes. Next.
That's one submission if I may make. Allah, they approached this honorable court. This honorable court dismissed the writ petition holding that they should go and file appeal before KAT. That I have annexed along with my IA for vacating stay. Yet, my lords, collateral proceedings are being filed. At least my IA may be considered to deliver possession of the property because
The auction
this
purchaser.
auction purchaser is issuing notices to me.
I the list day after tomorrow in the fresh matter.
And more than my lord, without taking the prior, they have not taken possession also. They have not taken.
Let's see.
23 BC Gnanaya Swami.
Writ of mandamus, your lordship, considering the
ಏನ್
writ.
mandamus?
Please, annexure.
Interim order ಇದೆ?
Interim order ಇದೆ ಸ್ವಾಮಿ, but your lordship, ಕಾಮಗಾರಿ ಮಾರ್ಕೌಟ್ ಕೊಡೋ ಇದ್ರ
No,
ಬಗ್ಗೆ.
so after the change of the government, now there is a direction by the government, my lords, not to permit, my lords, without the permit to work, without the, my lords, the sanction from the concerned department. So ಈ ಕೇಸಲ್ಲಿ ಅದೇ ತರ ಆಗಿದೆ. They are not permitted. my lords.
ಆಲ್ರೆಡಿ ವರ್ಕ್ ಆರ್ಡರ್ ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದಾರೆ.
Order ಇದೆಯಲ್ಲ?
ವರ್ಕ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Work order is
ಮಾರ್ಕೌಟ್
issued.
ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ.
Work is not started.
ಅಲ್ಲ,
Start ಮಾಡಿಲ್ಲ?
Due to the change of the government, my lords.
ಇಲ್ಲ ಇಲ್ಲ ಸ್ವಾಮಿ.
Further.
MP ಎಲೆಕ್ಷನ್, ಲೋಕಸಭಾ ಎಲೆಕ್ಷನ್.
The agency has the instruction pending consideration. Not to change the agency. ಇದೆಯಲ್ಲ entry order ನಿಮ್ಮ ಪರವಾಗಿ.
ಅಲ್ಲ ಇದೆ, ಡಿಸ್ಪೋಸ್ ಮಾಡಿಬಿಟ್ರೆ ನಾನು ಐ ವಿಲ್ ಸಾರ್ಟ್. ಬೇಕಂದ್ರೆ ಆಲ್ರೆಡಿ ವರ್ಕ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Work ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
12/3/2024 ಮೇಲೆ.
Consider his representation, my lords, within.
The petitioner is before this court seeking the following prayer. The petitioner participates in a, participates in a tender notified on 21/12/2023. Work order is issued. The petitioner emerges successful. Work order is issued in favor of the petitioner. Agreement is also entered into, but the work is not permitted to be executed. On an apprehension that the respondents may change the agency, the petitioner was before this court. As this court on 10/7/2024 protected the interests of the petitioner by the following order. This interim order is subsisting as on, even as on date. The learned counsel for the petitioner submits that if a direction is issued to consider the representation and permit the petitioner to work in terms of the representation, it would suffice for the present. The learned AGA would submit that if a week's time, if a fortnight's time is granted, the representation of the petitioner would be considered and the petitioner would be permitted to execute the work in accordance with law.
4 weeks more.
4 weeks, in accordance with law. In that light, I deem it appropriate to dispose the petition directing the respondent to consider the representation of the petitioner and pass necessary orders for the purpose for which it is given, purpose for which it is submitted, bearing in mind the observations made in the course of the order, with an outer limit of 4 weeks. 4 weeks from the date of receipt of the copy of this order. Yes.
Apologies. My apologies, my lords. In serial number 22, interim order may kindly be extended.
24, Jagdish Patil.
Appear for the petitioners. In the year 2022, in the committee for the promotion, our names were referred. Till today, your lords, we are not for the promotion. This is the, in respect of the horticulture department. Reject ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ. That's what they have challenged you. Earlier, this honorable court directed them
As
to
per existing C&R.
register. Existing C&R ಮಾಡಿದ್ರೆ ಸಾಕು ನಾವು ಅಷ್ಟೇ ಅಂತ ಹೇಳಿ ಬಂದಿದ್ದು. Earlier, this honorable court.
My lords, the difficulty for us is horticulture universities in the state are following different C&Rs. We have moved the government since last 2 years, my lords, to frame a common C&R. The government is holding the file.
ಅವ್ರು ಮಾಡಲ್ಲ ಬಿಡಿ, 10 ವರ್ಷ ಆದ್ರೂ ಮಾಡಲ್ಲ. ಅವ್ರಿಗೆ
But there is a there are two sets of writ petitions are there. The other cadre persons are disputing their claim.
Yes. Then why should the teachers or whoever be put to jeopardy because of the inaction of the state?
When the university was established, this UHS Bagalkot was established in 2009, new university, my lords, to accommodate, my lords, to meet the immediate urgencies, some persons were, my lords, absorbed from that cadre. Now, my lords, there is a clash between two cadres. The other writ petition also before your lordships now.
ಎಲ್ಲಿದೆ ಅದು?
Connected writ petition.
24.1.
Yes.
Yes.
So whatever decision lordship takes, we will abide by it.
Existing C&R, and there are 2 C&Rs now. The learned counsel for the respondent submits or projects his inability to grant the inability to accede to the prayers that are made in the subject petition on the score that after the university,
UHS Bagalkot.
after the University of Horticulture Sciences Bagalkot was established, the separate C&R that is framed is sent to the government, or a common C&R ಯಾವುದಕ್ಕೆ?
For all purposes.
For all purposes.
Recruitment, promotion,
For teaching and non-teaching.
Teaching and non-teaching, both.
ಈಗ C&R ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ?
They are adopting the Dharwad.
UAS Dharwad.
Dharwad at the inception.
It was a
But in respect of others, already they have granted the promotion on the very existing rules.
Then ಇವ್ರಿಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ನಮ್ಗೆ ಅಷ್ಟೇ ಕೊಡ್ತಾ ಇಲ್ಲ.
2009 lords, to meet the immediate exigencies, certain promotions are given.
What
Now-
exigency? ಆ ತರ you can't do it.
What has happened? May I make one submission, my lords? Coordinate bench of this honorable court has already held that unless and until C&R is not finalized, no promotions are to be made. Same university.
The government is sitting over the matter. We have provided all information.
ಕೊಡಿ.
Number of
ಯಾವ್ದು
documents are
judgment?
given.
C&R ಆಗೋರ್ಗು ಪ್ರಮೋಷನ್ ಕೊಡಬಾರ್ದು ಅಂತಿದೆಯಾ?
Last operative portion of the order.
ಅವ್ರು 10 ವರ್ಷ ಮಾಡಿದ್ರೆ
ನಾನು ಅದೇ then what is the
They clarify new C&R rules, my lords, all the issues will be resolved. Both the writ petitions can go.
the learned HCG ಹಿಂಗ್ ಮಾಡಿ, the petitioners are employees of the University of Horticulture Sciences Bagalkot, which was carved out of University of Agricultural Sciences Dharwad.
Dharwad.
The cadre and recruitment rules were also borrowed from University of Agricultural Sciences Dharwad. No separate cadre and recruitment rules are existing in University of Horticulture Sciences Bagalkot. Therefore, there is a stalemate with regard to the promotions to be granted to its employees. The learned counsel Jagdish Patil submits that the existing C&Rs are certain promotions are granted, taking the promotions are granted in terms of the C&R, existing C&R, which is the C&R of University of Agricultural Sciences Dharwad. But in case of the petitioners, they said benefit is not granted. Counsel for the respondent submits that it is 2 years ago that the requisition is sent to the state for a common C&R to be notified, or a separate C&R to the University of Horticulture Science Bagalkot to be notified. The state has not reacted for the last 2 years, which has led to gross prejudice to the employees of the Horticulture University. Therefore, the state shall secure instructions as to what has become of the communication and place it before the court on the next date, 27th, fresh matters.
Order copy.
ವಾಪಸ್ ಕೊಡಿ. ಇದು ಮುಗೀತು ಹಿಂಗಾಗ್ಬಿಟ್ರೆ ಅವ್ರು ಮಾಡೋದೇ ಇಲ್ಲ. Yes.
PN Molimani?
20? ಏನಿದೆ 25.1234? Regularization.
Teaching assistant and guest faculty, my lords. Teaching assistant and guest faculty. Lords, wherein every year the new notification will be issued.
Guest lecturer.
Please, my lords.
Barli. March, yes.
My lords, 25,
Apex court has protected our interest.
29 and 31, my lords.
Apex court has protected our interest, not to.
Yes, yes. Entry matter ಇದೆಯಲ್ಲ ಈಗ?
Intermodal.
26
List
Gayatri
on
sir?
29 and 31, my lords.
List in the first week of March, entry matter subsisting will continue to the next date of year.
Lords, Ramchandra Mali date may be, name may be, Ramchandra Mali name may be deleted, my lords.
My lords,
ಯಾವ್ದ್ರಲ್ಲಿ?
what has happened in this case, my lords?
Mali ಇಲ್ವಾ?
My lords, even though the take notice has been ordered, in many of the matters, copies has not been served, my lords, till today.
ನಿಮಗ?
Please, my lords, either to the directing advocate or to the.
ಬರ್ಕೊಳ್ಳಿ. Petitioner to serve complete set of papers upon the counsel Girish Ulmani appearing for the second respondent university in all these cases. If the copies are not served immediately, copies are not served in the next 1 week, the interim order subsisting would stand automatically vacated. Yes, the registry to delete the name of Ramachandra Mali as appearing for the respondent.
Please.
26 Gayatri sir?
May I request it on Monday, my lords?
Why Monday, madam?
There is some inconvenience, my lords.
Interim order ಇದೆಯಲ್ಲ?
Interim order ಇದೆ. It is very short matter, my
It's
lords.
on 6th March, yes.
Interim order kindly be extended.
Interim order subsisting will continue.
27, there was a direction for me to serve a copy on the counsel representing the respondents for a trial court. Notes before first court, my lords, the counsel representing respondent has expired. Before appellate court, my lords, the counsel has been appointed as an APP. Hence, I am unable to.
Emergent notice to the respondents. Returnable by the 13th of March. Yes.
Please.
28 Shivraj S. Baluli, CVMD?
Retail petrol bunk, my lords, rival retail petrol bunks. My contention is, my lords, twofold contention. One, my lords, the other petrol bunk is within 200 meters from my petrol bunk. Second, my lords, that the fifth respondent, the contestant,
Deputy Commissioner is issued now.
he has issued a no objection certificate to run the retail outlet. But, my lords, the retail outlet is being run in gross violation of, my lords, the conditions mentioned in the no objection
Whose
certificate.
retail outlet?
My lords, the fifth respondent.
Where is fifth respondent?
He served and unrepresented. my lords.
Hello, are 4 ಮಾತ್ರ ಇದೆ ಇಲ್ಲಿ?
Sorry, my lords. Second respondent, my lords. My apologies.
Yes, sir.
My lord, the rival retail outlet operator cannot question the establishment of another retail
The
outlet.
motor vehicle tax, motor vehicle ಕೊಡ್ತಾರೆ.
Pardon, my lords? There are.
Mithilesh Garg.
Pardon, my lord?
Mithilesh Garg.
Yes, my
How
lord.
judgment?
3 decisions, my lord. One is in the nature of PIL, that
Yes, sir.
here, my lord, about 3,000 to 4,000 retail outlet were notified, my lord. The Karnataka State Petroleum Dealers Association, they preferred.
In addition to this, I filed a memo, my lords, dated 12th February 2025.
Also, my lord, another 2 decisions, my lord, of this honorable.
ಎಲ್ಲ ಕೊಡಿ.
Also have annexed R1, one
Yes,
division.
My only
bench
submission
decision.
is, my lords, if he wants to,
Of March, yes.
the continuation of the outlet itself is illegal and contrary to, my lords, the very conditions are imposed, my lords.
My lords, one more decision, I have made it as annexure R1, division bench decision.
Next.
Please.
Number 29 PN Molimani?
Same. 29 and 13 ಅಷ್ಟೇ same.
Cell number 30 K Anand Kumar?
My lord, petitioner,
Your lordship,
the government undertake to
please.
report to the court, my lord. The
In this
pension
matter,
paper-
your lordship, immediately after receiving the documents from the management, your lordship, we have sent.
Pension ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
No, ಆಗಿಲ್ಲ sir.
ಯಾವಾಗ?
ಇನ್ನೂ instructions ಬಂದಿಲ್ಲ.
Who is the
Delay
officer
caused
who-
because of the
Who is the
management.
officer who
Your
has to grant?
My lord, the second respondent sent to the all papers to the
Accountant general we have sent, your lordship.
ಡೇಟ್ಸ್ ಹೇಳಿ ಒಂದು ನಿಮಿಷ. ಯಾವತ್ತು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿದ್ ನೀವು?
My lord, I have filed along with memo, my lord. That was communicated
He retired on 31/5.
31/5
24, my lord.
31/5/2024. My lord.
ನೀವ್ ಯಾವತ್ತು ಕಳ್ಸಿದ್ರಿ?
10/12/2024.
ಯಾಕೆ 6 months ಯಾಕೆ ತಗೊಂಡ್ರಿ?
My lord, after collecting all the papers, my lord.
ವಾಟ್ ಆಲ್ ದ ಪೇಪರ್ಸ್? ಆಲ್ ದ ಪೇಪರ್ಸ್ ನಿಮ್ಮ ಹತ್ರ ಇರ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಅವರು ಇದನ್ನ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಏನ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
ಅವ್ರು ಕೋಆಪರೇಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. my
ಯಾಕೆ
lord.
ಕೋಆಪರೇಟ್ ಮಾಡ್ರಿ? ಪೆನ್ಷನ್ ಕೋಆಪರೇಟ್ ಮಾಡಲ್ವಾ ಯಾರು?
ಅಲ್ಲ ಬರೇ ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ರು.
ಮತ್ತೆ ಇನ್ನೇನ್ ಬೇಕು ನಿಮ್ಗೆ?
ಅಲ್ಲ ಅದು ರಿಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್, my lord.
ಏನ್ ರಿಲೆವೆಂಟ್ ಡಾಕ್? ನಿಮ್ಮ ಹತ್ರ ಇಲ್ದೇ ರಿಲೆವೆಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರ ಹತ್ರ ಏನಿರುತ್ತೆ? ಯು ಆರ್ ದಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಸರ್.
After direction of this
ಯಾವತ್ತು
court,
ನಿಮ್ಗೆ
my lord,
ಕೊಟ್ಟಿದ್ದು?
sent paper. After direction of this.
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕಳ್ಸಿದ್ ಯಾವತ್ತು?
10/12/2024, my lord, which was received in the office on 12/12/2024, second respondent in the second respondent office, my lord.
Now, for delay of 6 months, you will pay costs, which will be deducted from the grants. And from delay, from 12/12/24, the officer will have to pay costs from his pocket. The petitioner, a retired teacher, is at the doors of this court wanting to get his pension, as the pension is not settled despite retirement happening 8 months ago. The petitioner retires on attaining the age of superannuation from the third respondent institution on 31/5/2024. In terms of the extant rules, it is incumbent upon the institution to keep the documents ready a month prior to the date of retirement so that a retired employee would peacefully retire and receive his pension. That is seldom done in any quarters of the state. The classic illustration of such delay is the subject case. The management takes 7 months to communicate the documents that are already available with it to the state to process the papers of pension. It is for the first time after this court issued notice, the management has forwarded the papers of pension on 10/12/2024, which has reached the competent authority on 12/12/2024. Today, we are at 19/2/2025. No pension is paid to the petitioner, which has left him in the lurch. Therefore, the learned HCGP is on the estimate time, madam. Learned HCGP has gone on seeking that the pension would be paid by the next date of hearing. This court on 17/1/2025 had passed the following order. It was already observed that the coercive arm of law would be unleashed against respondents in the event pension papers are not transmitted or pension is not paid. Therefore, the petitioner becomes entitled to costs assessed at rupees 1,000 per day till the pension is paid to the petitioner, apart from the interest that he would get on pension payment from 31/5/2024 till the date the pension reaches the petitioner. The costs to be paid by the officer who has kept the file pending without processing the pension papers from 12/12/2024 till the date of payment. Insofar as the role of the management is concerned for having kept the papers of the petitioner pending for 7 months, the ಎಷ್ಟು 50,000 cost of 50,000 is imposed upon the management. Upon the management to be paid to the petitioner. It is open to the state to recover the same from the hands of the management.
Your lordship.
The pension ಯಾವ್ದು ಕೊಡ್ತೀರಾ?
Immediately after receiving the documents from the management, Your Lordship, we have remitted it on 24/1/25, Your Lordship.
Don't know.
ಅಲ್ಲ
Yes.
ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ನಾವು ಕಳಿಸಿದೀವಿ ಸ್ವಾಮಿ.
List the matter for
Your Lordship.
further hearing on 7th March.
We have sent the documents, Your Lordship. ಅಲ್ಲ there is no lapse
ಇದು
from
ಮಾಡದೆ
our
ಹೋದ್ರೆ
side.
ರಿಟೈರ್ಡ್ ಪೀಪಲ್ ಜೊತೆ ಆಟ
ಅಲ್ಲ
ಆಡೋದಿಲ್ಲ ನೀವು.
ಒಂದ್ ತಿಂಗಳಲ್ಲಿ ಅವ್ರು ಕಳಿಸಿದ ತಕ್ಷಣ ನಾವು ಕಳಿಸಿದೀವಿ ಸ್ವಾಮಿ.
ಅದಕ್ಕೆ ಅವ್ರಿಗೆ 50,000 1 ಲಕ್ಷ ಹಾಕೋಣ.
ಅಲ್ಲ that observation, Your Lordship, ಅಲ್ಲಿ ಬರೋವರೆಗೂ ನಾವು
That will do.
from
50,000 costs management all right.
Your
Yes.
Lordship, that observation may be
Apart from interest ಎಲ್ಲ ಅದು ಫೈನಲ್ ಆರ್ಡರ್ ಬರೀಬೇಕಾದ್ರೆ ಮಾಡ್ತೀವಿ.
24/1 ಗೆ ನಾವು we have sent the documents.
We'll
Your
observe
Lordship.
all that.
Kindly, Your
No
Lordship.
madam. Teachers ಗೆ pension ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ I'm not going to keep quiet.
ಅಲ್ಲ 1 month
They are
there
not
is
like
delay, Your
office,
Lordship.
they are not like officers
Yes, yes.
who are otherwise very well off.
ಅಲ್ಲ
They are
1 month
teachers.
there is delay on our part, Your Lordship. ಅಲ್ಲ ಬರೋವರೆಗೂ ಅಂದ್ರೆ ಕಷ್ಟ.
No.
ಅಲ್ಲ observation, Your Lordship, immediately after receiving the documents from the management, Your Lordship,
Correct.
within 1 month we have sent it.
1 month.
ಅಲ್ಲ
Why?
ಅಲ್ಲಿಗೆ ಬೇಕಿದ್ರೆ Your Lordship,
Nothing. No madam. Yes.
Yes.
Number 32, Jagdish Patil.
Respondent, my lord, today I got the instructions from the parties. My lord, in fact,
Objections.
objections.
Okay.
Three family members have
Just
already.
in the second week of March, objections if any by then. Next.
33, MB Hireman. Venkatesh Kharvi.
My lords, kindly have it on next week, my lords. I have filed a statement objection, my lords.
Second week.
Much obliged.
Yes, March. Objections if any by then.
34, MB Hireman Dayanand Mandi.
Please, my lord.
Lord, today I filed a wakalat, my lords.
34, my lord.
ನೀವೇನ್ ಕರೆದ್ರಿ?
Today I
Yes,
filed
my
a
lord.
wakalat, my lords, and a 3 days time may kindly be granted.
Yes, sir. Yes, sir. 26 ತಿಂಗಳು.
ಅದೇ, today I filed a wakalat, my lord. I informed him to give
That
instructions.
is not the concern of the court.
My lord, on
26 months pension is not settled.
ಅಲ್ಲ ಪೆನ್ಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಬಗ್ಗೆ I have taken instructions. As per my instruction, my lord, probably they settled all the retirement benefits. Probably, that's why.
Just on Monday in the fresh matters.
Yes, my lords.
35, Santosh Pirao.
Your Lordship, in this matter also, Your Lordship, posting,
Till today, they have not given posting, my lord. And the interim order passed by this honorable court has been stayed by the division bench, my lord.
Which one, sir? ಯಾವ entry order?
ಈ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇರೋ interim order ನ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ
Background approval ministry is it is unnecessary how approval still retained despite the order dated 31. Division bench stay ಮಾಡಿದಾರ ಇದನ್ನ?
ಮಾಡಿದ್ದಾರೆ.
Which order?
My lord, interim order of
ಯಾವ entry order, sir?
first ತಗೊಂಡಿದ್ದು interim order.
ಪ್ರದೀಪ್ ಸಿಂಗ್ ಸಾಹೇಬ್ರದ.
As on today, I am not.
ಇದು one pay scale ಕೇಸ್
ಹೌದು.
ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ಮೇಡಮ್?
ಅಲ್ಲ
ಮತ್ತೆ ಅದಕ್ಕೂ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಾ? ಯಾವಾಗ? He appears to be very influential.
weeks time, Your Lordship.
No weeks time. I will impose costs again.
Monday ವರೆಗೂ
No Monday. I am taking it on Friday morning. If posting is not given to him by then definitely we will pass some order against the officer who is holding on to the file despite the orders of the court. Yes. List on Friday in the fresh matters list.
36, SB Hebbardi. Shiv Nilopal.
1 week's time for art.
Chancellor.
Yes.
Second week of March.
37, MS Harvey. Prashant S. Vasmani.
Respondents have initiated parallel proceedings, my lord, against the petitioner.
Lords, the Lokayukta complaint, my lords. In this case, my lords, the trap was, lords, to release the gratuity amount of a deceased employee, my lords, they are both the petitioners, 37 and 38, serial number 37 and 38, both. My lords, they had demanded money. My lords, complaint was filed, my lords, they were trapped. Then, my lords, 3/3/2022, my lords, is the complaint, FIR. Then, my lords, charge sheet.
Criminal case ಏನಾಯ್ತು?
Criminal case, my lords, is pending. Charge sheet is filed on 36/2023. There, 1 year thereafter, my lords, articles of charge for DE, my lords, is issued. Now, my lords, as far as departmental inquiry is concerned, my lords, that is based upon, my lords, no doubt the complaint, my lords, of filed by the Lokayukta. But, my lords, there, my lords, what we are investigating is whether his conduct, my lords, has a.
interim order has been granted.
There is an interim order.
ಎರಡರಲ್ಲೂ ಮಾಡಿದ್ದಾರೆ.
ಎರಡರಲ್ಲೇ ಆಗಿದೆ.
List in the second week of March. Interim order subsisting will continue to the next date of year.
Please.
38.
Same.
38 also.
Same, 37, 38.
Ravi Hegde, Prashant Osmani.
ಇದೇನು?
My lords, suspension orders, my lords.
All 8, 10
My
matters.
lord,
10 matters, my lords.
39.3 and 39.5.
ಏನು?
My lord, there was an interim order passed in these proceedings. It was not complied, my lord. Therefore, my lord, the contempt was filed, notice was issued. It is pending, my lord. That is the only difference, my lord, in this.
Pending inquiry, my lords, they are suspended. My lords,
What is wrong with the suspension, sir? Adeli.
Lord, here,
What is the statutory violation
39
in suspension? ಏನ್ suspension charge sheet ಒಂದೇ ದಿನ ಮಾಡ್ತಾರೆ?
ಒಂದೇ ದಿವಸ ಮಾಡ್ತಾರೆ.
ಪರವಾಗಿಲ್ಲ, ಆಮೇಲೆ
ಒಂದೇ ದಿವಸ ಮಾಡ್ತಾರೆ. And my lord, no apprehensions are expressed.
by what?
Continuing, my lord, him would be detrimental to the.
Too much ಆಗೋಯ್ತು. Suspension ಎಷ್ಟು ತಿಂಗಳಾಗಿದೆ ಈಗ?
my lords, in fact, in all these cases, my lords, except
Already, my lord,
suspension is for 1 month. Then, my lords, after revocation of suspension, my lords, he is transferred, my lords, to.
Work ಆಗಿದೆಯಾ ಎಲ್ಲಾದ್ರಲ್ಲೂ?
In, my lords, almost all cases.
But what's your
Except,
grievance,
my lords, 1 or 2
ಇದ್ರಲ್ಲಿ
cases.
ಆಗಿಲ್ಲ.
What's your grievance, sir?
ಮಡಿವಾಳಪ್ಪ ಶಿಗೇಹಳ್ಳಿ, my lord, the first case. It was not
ಅದು
revoked.
revoke ಮಾಡ್ತಾರೆ.
It is
No such,
revoked. He, my lords, and he is transferred to some other depot. He has not joined.
That is a separate cause of action.
No, now, my lords, the second prayer in the writ petition is to put him back in the same place.
That I will not grant.
The other violation,
Place your apprehension that you being there will
That
create a
is, my
problem.
lords.
ಇವ್ರೇನೋ ಪೂರ್ತಿ ಆರ್ಡರ್ ಕ್ಲಿಯರ್ ಆಗಿ ಬರೆಯಲ್ಲ ಅಂದ್ರೆ ನಾವು ಅದನ್ನ ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes.
Except in one case, in all cases, my lord, suspension has been revoked, and they have been, my lord, transfer orders are passed. In few of the cases, they have, my lord, joined to the post where they were now transferred. Some
Lord,
of them have
the
become infructuous.
modus operandi is, my lord, suspension. My lord, the purpose of, my lord, is aware.
Yeah.
The reason is, my lord, to keep him out of mischief range. My lord, they are all class 4 employees. Throughout the day, they will be on bus. There is no access to the official documents in view of issuance of charge sheets. And they have settled down their family and the student, my lord, children are studying in the school.
Yeah.
The modus operandi is, my lord, without any apprehension. They don't have access to any official documents. Witnesses are notified, they are in the custody of the management. So unnecessary, my lord, transfer is.
No, can I foresee what you will do there? ವಾಪಸ್ ಅಲ್ಲಿಗೆ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲೋ ಕೆಲಸ ಮಾಡ್ಬೇಕು.
That is correct, my lord. This is, my lord, used as a tool in order to accommodate somebody else in my place. In many of the cases, my lord.
That's a separate thing. If you challenge that, we'll see. But ಏನಾಗುತ್ತೆ? Suspended employee to be revoked. We cannot by a judicial order say he should be posted there only.
My lord, there are even government, my lord, he should not be placed in a sensitive places. ಅವೆಲ್ಲ ಇದಾವೆ. ಇದರಲ್ಲಿ ಅಂತದ್ದೇನಿಲ್ಲ. Our drivers, conductor ಎಲ್ಲಿ ಇರ್ತಾರೆ? Throughout the day, my lord, they are in the bus. Why, my lord, unnecessary trouble for them? That is, my lord.
Because you created trouble for them.
Lords, in most of the cases, my lord, is a case of pilferage.
And in many of the cases, my lord, what.
I for one will not pass that order at all. Again,
what transpires is, my lord.
My lords, 39, 39.1, 39.2, my lords, they have become infructuous because they went and joined where they are transferred now.
39,
39.1 and 39.2.
39.1 and 39.2.
Infructuous.
Okay.
Then, my lords, there are other matters also.
ಅಲ್ಲ ಅದು ಯಾವಾಗ ರಿವೋಕ್ ಮಾಡಿದಿರಿ ಅಂತ ಹೇಳ್ಬಿಡಿ ಕರೆಕ್ಟ್ ಆಗಿ.
ಕೇಳಿದ್ರೆ ಎಲ್ಲಿ ಜಾಯಿನ್ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
39.6.
ಒಂದು ನಿಮಿಷ ಪ್ರಶಾಂತ್.
Please.
One moment. 30, 39, 39 point, ಈಗ 39 ಅಲ್ಲಿ ಏನು ಒಂದೊಂದಾಗಿ ಹೇಳಿ.
Please, my lords, first matter ಕೊಡ್ರಿ.
ಗೊತ್ತು ಯಾವ್ದ್ರಲ್ಲಿ
My lords, he
39.4
ಒಂದು
is
ನಿಮಿಷ.
already revoked. And also he joined the duty, my lord.
ಅದು infructuous, yes.
And also subsistence allowance and my lord salary also paid to him.
ಅದೇನ್ complaint ಅಲ್ಲ ಬಿಡಿ, that's not the complaint.
My lord, they have
ಪ್ರಶಾಂತ್, ಇದು
My lords, in the first matter, 39 ದಲ್ಲಿ, my lords, 13th January to 2025, my lords, it is revoked.
13th
January
2025.
It is revoked.
Next.
And my lords, he has joined to the post where now my lords he is.
All right.
Then my lords, second case, 104377. It's 29/2024, it is revoked. But he is now continued in the same place because of the interim order.
Suspension interim order ಇದೆಯಾ?
Oh, now he is continued in the same post because of the interim order.
We'll see, yes. Next, 39.2.
Notes 39.2, it is suspension order is revoked on 8/10/2024. He was transferred to Belgaum Depot where he has joined. So this
All
he has
right.
become
Next,
infructuous.
39.3.
3, my lords.
ಹತ್ರ ಇದ್ರೆ ಜಾಯ್ನ್ ಆಗ್ಬಿಡ್ತಾರೆ. If it is, my lord, sometimes
Right.
far away places that disturbs
Next.
their family.
39.3.
3, my lords, it is revoked.
No, it is not revoked, my lord. There was an interim order passed.
ಯಾವ
And
39.3 ಅಲ್ಲಿ
39.3 ಅಲ್ಲಿ. Then, my lord, request was made, notice was issued, then there was no compliance.
All right, ಅದ್ರಲ್ಲಿ contempt ಹಾಕಿದ್ದೀರಾ?
Contempt was filed.
ಸರಿ, ನೋಡೋಣ.
And they have not,
Anyway,
even
interim
today
order
they have
ಇದೆ
not
ಅದ್ರಲ್ಲಿ.
complied.
ಆಮೇಲೆ 39.4 ಅಲ್ಲಿ have joined.
My lord, 19/12/2024.
19/12/24.
24. He joined my lord in the original place, my lord.
Joined. Original place ಗೆ ಹಾಕಿದ್ದೀರಾ? All right. Next, 39.5.
My lords, 39
ಐದಲ್ಲಿ there was an interim order, my lord, against
ಐವಲ್ಲೂ
which
interim order ಇದೆಯಾ?
interim order.
interim order ಇದೆ. There was a contempt proceedings which are pending.
39.6.
6, my lords,
Vintage Karvi.
revoked on 22/1/2025.
ಇದೆಯಾ interim order? ನಾನು ಅದಕ್ಕೆ ಇವ್ರು ಯಾಕೆ ಆ ಕಡೆ ಇದ್ದಾರೆ ಅಂತ ನೋಡ್ತಾ ಇದ್ದೆ. Petitioner, yes.
In
39.7.
No, 6, it's also infructuous because it is revoked and they have joined also.
Interim order ಇದೆ ಅಂತಲ್ಲ?
ಇಲ್ಲ 39.5 ಅಲ್ಲಿ ಸರ್.
ಅಲ್ಲ
5 ಅಲ್ಲಿ ಇದೆ.
ವೆಂಕಟೇಶ್ ಕಾರ್ವಿದ್ರಲ್ಲಿ interim order ಇದೆ ಮೇಡಮ್. ಆಯ್ತು, ನೋಡೋಣ, we'll see. Yes, next. 39.7.
7, my lords, revoked on 11/2/2025 and he is transferred, my lords, to Hungund.
Joined.
Joined.
39.8.
Lords, 11/2/2025.
Same.
Joined. Here, my lords, in this last matter, there is revoked, my lords, in exact date, my lords, is not forthcoming, but on
revoke ಆಗಿದೆ.
30th November, my lords.
30/11/24. Joined.
Joined on 21/25, he has joined Dandeli Depot.
ಒಂದೊಂದಾಗಿ close. First 107443 ಕೊಡಿ ಮೇಡಮ್. The petitioners in all these cases call in question the act of the employer placing these petitioners under suspension and ಅದೇ ಕೇಳಿರೋದ ಏನು, and a direction to reinstate them back into the same place. Few of the petitions are rendered infructuous by subsequent events is the submission of the counsel for the respondent Prashant Hosmani. In writ petition 107743 of 2024, the suspension comes to be revoked on 30th January 2025 and the petitioner is posted to another place where he has reported to duties. Therefore, the said petition is rendered infructuous as there is no other relief that is sought at the hands of this court.
13th January, 13. 13.
13/1/2025. 13. 13.1 ಅಲ್ಲಿ ಫೈಲ್ ಕೊಡಿ ಮೇಡಮ್.
39.3.
ಇದು ರಿವೋಕ್ ಆಗಿದೆಯಲ್ಲ?
Please, my lords. This is also 13.1. It is revoked.
The petitioner in the subject petition seeks an identical relief of quashment of the order of suspension and put the petitioner back to the same post. It transpires that an interim order is granted. 39.2 na madam ಕೊಟ್ಟಿದ್ದು 1 ಆಯ್ತು 104377 ಯಾವುದು ಇದೆ ಇದರಲ್ಲಿ ಹೇಳಿದೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ನೋ ಎಂಟ್ರಿ
ಯಾವ್ದ್ರಲ್ಲಿ
ಸೆಕೆಂಡ್ 39.1 ಅಲ್ಲಿ
26
ಇದೆಯಾ 7 39 ಇದು ಯಾವುದು ಆರ್ಡರ್ ಶೀಟ್ ಯಾವ್ದ್ರದ್ದು ಇದೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ಎಲ್ಲದ ಆರ್ಡರ್ ಆಫ್ ಸಸ್ಪೆನ್ಷನ್ ಇಸ್ ಸ್ಟೇಡ್. This court, in terms of its order dated 26/7/2024, had stayed the order of suspension. During the subsistence of the petition, the respondent corporation has revoked the order of suspension on 20th September 2024 and directed him to be directed the petitioner to report to duties. The petitioner has not joined in the light of the interim order subsisting. It is made clear in the interim order, the order of suspension was stayed, which is no longer in existence as the corporation has revoked the order of suspension. Therefore, it is for the petitioner to abide by the revocation of order of suspension and the place of posting. The petition in the light of the revocation of suspension is rendered infructuous. Next, 39.2. The challenge in the case at hand is to the order of suspension. During the subsistence of the petition, it transpires that the corporation has revoked the order of suspension on 8/10/2024 and the petitioner has joined to the place where he was directed to report. Therefore, the petition is rendered infructuous and is disposed as having become infructuous. 39.3. The petition, the challenge is to the order of
my lord, there is a
There are two
contempt.
petitioners. There are two petitioners in this case. Lords, in respect of both, my lords, it is in respect of petition number 1, it is revoked on 8/10/2024. And in respect of the second petition also on 8/10/2024.
Joined,
My lord, here,
Not joined because of the interim order.
here, my lord, I have questioned not the, my lord, the revocation of transfer order is not questioned.
revocation of suspension.
Suspension is not questioned.
And what have you
At
questioned?
a consequence, my lord, there was a transfer order made at annexure F. Only portion is questioned, my lord, that amounts to punishment transfer without holding an inquiry.
ಯಾವುದಕ್ಕೆ
My lord, kindly annexure F, my lord, kindly.
punishment transfer, sir?
The order is, my lord, kindly take, my lord, annexure F. They have, my lord, revoked the suspension order.
Posted you where, sir?
Posted you somewhere else, my lord,
You
in the same order.
ಮುಂಚೆ ಎಲ್ಲಿದ್ರೆ ಅಲ್ಲೇ ಇರಬೇಕು ಅಂತನಾ?
Therefore, my lord, it amounts to transfer. My lord, that cannot be, my lord, made in view of, my lord, the judgment of this court. It amounts to punishment transfer ಅಂತ question ಮಾಡಿ.
ಏನ್ ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ವಾಪಸ್ ಅಲ್ಲೇ ಹಾಕ್ಬೇಕಾ?
My lord, the order does not reflect that continuing that employee would be detrimental and, my lord, he may play some mischief and he may manipulate the documents.
Much from the delinquent employee who is suspended on account of pilferage of funds. I will observe.
My lord, that is yet to be decided whether I may be exonerated or not.
Till in the month.
That, my lord, before
Posted to the same place, sir.
before conclusion, my lord, if they are posting me somewhere else, then, my lord, it amounts to indirectly punishing an employee. It amounts to a punishment transfer. Punishment transfer.
We will hear this later. 39.3 delink ಮಾಡಿ. The ಈಗ dismiss ಆದ್ಮೇಲೆ then you will face proceedings if you don't join.
ಹೌದು.
ಆಯ್ತು.
Contempt is also pending, my lord.
ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ. Yes. The petitioner 39.3 ಆರ್ಡರ್ ಬರ್ಕೊಳ್ಳಿ. The suspension orders that are called in question have today become redundant, become infructuous, for the reason that both the petitioner's orders of suspension are revoked on 8/20/24. The counsel for the petitioner submits that on revoking the orders of suspension, the petitioners are transferred to some other post. It is his contention that they should be posted back to the same place. The learned counsel Prashant Hosmani submits that the allegation against these petitioners are misappropriation or pilferage of funds of the corporation, and they cannot be posted to the same place so that they would indulge in acts that would prejudice the corporation. However, the learned counsel submits that the transfer of this kind would amount to a punishment which prima facie I do not accept, but matter requires to be heard, lest the matter in the first week of March 2024. Interim order subsisting will continue till the next date of hearing. ಇದರಲ್ಲಿ contempt close ಆಗುತ್ತೆ.
Yes. In the next time, the 39.4.
Next.
39.5 ಅಲ್ಲೂ ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಬಹುದು.
39.4 the
infructuous
revoke ಆಗಿದೆಯಲ್ಲ?
Revoke.
The challenges to the order of suspension. The suspension comes to be revoked by an order dated 30/11/2024, and the petitioner has joined to the place of posting. Therefore, the petition is rendered infructuous.
Yes.
39.5.
5 ಅಲ್ಲಿ ಸೇಮ್ ಆರ್ಡರ್ my lord. Contempt is pending and
39.5 and 39.3 same order. Yes, 39.6 Venkatesh Karvi. ಅದು ಜಾಯಿನ್ ಆಗಿದಾರಾ?
He has joined. He has joined.
The challenges to the order of suspension. The suspension is revoked during the pendency of the subject petition, and the petitioner is said to have joined the place of posting. Therefore, the petition is rendered infructuous. Same 39.7. The challenges to the order of suspension. The suspension is revoked during the pendency of the subject petition on 11/2/2025, and the petitioner has joined the place of posting. Therefore, it is rendered infructuous. Next to same date, madam, 11/2/25, 39.8. 39.9 only. The petition challenges to the order of suspension. The suspension stands revoked on 30/11/2024, and the petitioner has joined the transferred place. Therefore, the subject petition also becomes infructuous. Is disposed as having become infructuous. Yes. ಎರಡು ಮಾತ್ರ ಉಳಿತಿರುವೆ. Contempt ಗಲಾಟೆ ಮಾಡಿ.
Number 40 Raghavendra Purohit.
Lord, petitioner seeking my lord parole, my lord.
Parole
matter.
Yes, AGA. First time ಬರ್ತಾ ಇದೆಯಾ?
Non-compliance ಅಲ್ಲಿ ಇದೆ.
AGA is directed to accept notice.
ಇದರಲ್ಲಿ annexure D, it is rejected it seems.
ಏನು?
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಒಂದ್ಸಲ.
Annexure D
ಅಪ್ಲಿಕೇಶನ್
is
ಹಾಕಿದ್ರು,
rejected,
30 days
that I
parole
have
ಅಪ್ಲಿಕೇಶನ್
challenged
ಹಾಕಿದ್ರು.
ಯಾರು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ?
ಅಲ್ಲಿ ಜೈಲ್ ಅಥಾರಿಟಿ ಮೂಲಕ
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ, ಅವ್ರು ರಿಜೆಕ್ಟೇ ಮಾಡೋದು.
ಅಲ್ಲ ರಿಪೋರ್ಟ್ ಇದೆ, ಕಸ್ಟಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಎಲ್ಲ ಏನಿಲ್ಲ ಇದು.
ಏನಿದು? ವಾಟ್ ಇಸ್ offense ಏನು?
Offense 302 my lord.
ಎಷ್ಟು ವರ್ಷ ಇದ್ದೀರಾ?
Since 2007 my lord, he is in custody my lord.
Petitioner, who is the petitioner?
Who is the
convicted relationship ಏನು?
my lord, he is a convicted person my lord.
Convict only.
Convicted person.
The petitioner is before this court seeking his release on grant of parole. The petitioner gets embroiled in a crime for offense punishable under section 302 of the IPC. He is tried by the Court of Session in SC 21 of 2009 and is convicted of the said offense. The criminal appeal preferred against the said order of conviction also comes to be rejected. Therefore, the petitioner has been in prison since 2007 and as on today completed ಎಷ್ಟಾಗಿದೆ custody certificate ಅಲ್ಲಿ?
Custody certificate is
ಏನಿಲ್ಲ.
not produced.
ಹಾಕಿಲ್ಲ ಅವರು.
No, my lord.
Custody certificate.
Custody certificate is not produced my lord. Since he is my lord in
Get it? Yes.
Please.
New authors.
ಪ್ಲೀಸ್.
List on list day after tomorrow in the fresh matters list. Yes.
ಅಲ್ಲ ಮಂಡೇ ಅಂದ್ರೆ ಮೈಸೂರದಿಂದ
please.
Number 41 Shashank Hegde.
I appear for the petitioners, your lordship.
Today I'll file objections are ready.
Yes, Sita madam.
Your Lordship, we've not received the objections.
Today I will file.
If they file, you will receive it.
Today I will file, my lords. I will get today.
I
sir.
have to file it. Yes, the learned AGA submits that objections should be filed in the next 2 days.
2 days.
The objections be filed by the next date of hearing list on 14th March. Interim order subsisting would continue till the next date of hearing. Next.
Much obliged, Your Lordship.
Rajshekar Gunjali,
Compassionate appointment, my lord. Mother of the petitioner was working in.
Compensatory appointment.
Compassionate appointment.
Please. Petitioner is the son of the, my lord, deceased employee.
Son of?
Lord, employee, deceased
Date of
employee, my
death,
lord. One Kalakappa.
15/1/2021.
Please, my lord. On 2011-2001, my lord, application has given
So there is one
for
judgment.
compensate appointment.
Pass over. I'll take it at 2:30. 2:30 ತಗೊಂಡು.
Please, please.
ನೀವು judgment ಇದೆಯಾ ಕೊಡಿ.
ಇಲ್ಲ ತಂದಿಲ್ಲ.
There is a judgment, financial benefits should not be the consideration for consideration of appointment and compassionate grounds. ನೀವು ತರಬೇಕು, ನಾನು ಅಟೆಂಡ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನಾನು ತರಕ್ಕೆ ನಂಗೆ ಟೈಮ್ ಆಗ್ತಾ ಇಲ್ಲ. Yes.
I will get.
Yes, sir.
43.
In this case.
This is the matter.
Here. ಏನು ಹೇಳಿದ್ರಲ್ಲ.
Please, Lords. Idರಲ್ಲಿ, Lords, the notification is of Lords on 12/9/24.
12/9/24.
Annexed B, Lords. And the last date for Lords submission of tender is
91 days problem.
91 days.
20 date of tender.
12/9/24. Lords, on 14/10/24 is the last date to submit the Lords the tender. So limitation starts from 15th, Lords, 15/10. And order is issued on Lords on 10/1/25. So as per
10/1/25. Who is issued the work order? ಇವರಿಗ
ಕೊಟ್ಟಿದ್ವಿ.
ಯಾವತ್ತು 10/1/25.
25. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ Lords? On 10/1/25 Lords, as per the ಇದು ಮಾಡಿದ್ದಾರೆ, ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. 11th and 12th are Lords second Saturday and Sunday holiday. On 13th Lords secretary was on leave. 14th also Lords holiday. 15th they got interim order. 15th. So and one more thing, Lords. So far as not displaying in the Lords the website portal, his bid is Lords 15.3. So L1 ಇವ್ರಿಗೆ ಕೊಟ್ಬಿಡ್ತಾರೆ automatically. That cannot be changed. Less than 15.3.
Come back. What did you say?
In the portal, Lords, after they submit the bids, Lords, the lowest bidder will be shown as 11.
Correct.
So his bid is Lords minus 15 under 15.3 ಇದೆ. So he'll be 11 Lords. But he will be displayed as L1.
If he is the L1, what's the problem?
ಅಲ್ಲ, minus 15.3 minus 15 ಕಿಂತ ಕೆಳಗಿದ್ರೆ his bid is automatically to be rejected. ರಿಜೆಕ್ಟ್ ಆಗ್ಬೇಕು. ಬಟ್ ಇದ್ರಲ್ಲಿ ಏನಾಗುತ್ತೆ, ಇವ್ರದೇ L1 ಅಂತ ತೋರಿಸ್ಬಿಡ್ತದೆ ಸಿಸ್ಟಮ್ ದಲ್ಲಿ.
ಈಗ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಆನ್ 91 days 90 days ತಾನೆ.
ಇಲ್ಲ ಇನ್ನು ಬೇರೆ ಪಾಯಿಂಟ್ಸ್ ಇದೆ.
ಬೇರೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ತಗೊಂಡ್ರದು ಓನ್ಲಿ 90 days. ಬೇರೆ ಪಾಯಿಂಟ್ಸ್
ಕೈಂಡ್ಲಿ ಸಿ. ಇವತ್ತಿನ ಸ್ಟೇಟ್ಮೆಂಟ್ ನನ್ನ ರಿಸೈನ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ಲೀಸ್. ನನ್ನ ರಿಸೈನ್ಡ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಈ ಕ್ಷಣದಲ್ಲೂ ಸಹ ಈ ಪ್ರೊಕ್ಯೂರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ. ಈವನ್ ಅಂಡರ್ ಎವ್ಯಾಲ್ಯೂಯೇಷನ್ ಬರ್ತಾ ಇದೆ.
ನಿಮ್ ಪೋರ್ಟಲ್ ಅಪ್ಡೇಟ್ ಮಾಡಕ್ಕೆ
ಪೋರ್ಟಲ್ ಅಲ್ಲೇ
15th ಗೆ ಅವ್ರದ್ದು ಸ್ಟೇ ಆಗ್ಬಿಟ್ಟಿದೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಏನು ಮಾಡೇ ಇಲ್ಲ. 15th ಗೆ ಸ್ಟೇ ಆಗ್ಬಿಟ್ಟಿದೆ
ಸ್ವಾಮಿ.
ಯಾವುದು
15/1.
ಹೇಳಿ ಸರ್.
10th ಗೆ ಅವರು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರೆ, ಆರ್ಡರ್ ಕೊಡೋಕ್ಕಿಂತ ಮುಂಚೆ ಮ್ಯಾಂಡೇಟರಿ ಈಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಅಪ್ಲೋಡ್ ಥ್ರೂ ಈ ಪೋರ್ಟಲ್. ಈ ಪೋರ್ಟಲ್ ಅಲ್ಲೇ ಕೊಡ್ಬೇಕು ಅವರು. ಬಿಕಾಸ್
ಈಗ ವರ್ಕ್ ಆರ್ಡರ್ ಅವ್ರಿಗೆ ಇಶ್ಯೂ ಮಾಡಿರೋದು ಹೆಂಗೆ?
ಇಲ್ಲ ಅಲ್ಲ, ಅದಕ್ಕೆ ದಟ್ಸ್ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋ ಸಿಡಿ ಆಲ್ಸೋ.
ಮೈನಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
ಐ ಪ್ರೊಡ್ಯೂಸ್ ದಿಸ್
ಕೈಯಲ್ಲಿ
ಕೊಟ್ಟಿದ್ದಾರಂತೆ.
ಕೊಟ್ಟಿದ್ವಿ. ಅಲ್ಲ, ಸಿಡಿನೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ವಿ ಹ್ಯಾವ್ ಲಾಟ್ಸ್ ಮೀಟಿಂಗ್ ದಲ್ಲಿ ಅಲ್ಲ
ಪೋರ್ಟಲ್ ಅಲ್ಲಿ ಹಾಕಕ್ಕೆ
ಅದ ಗ್ಲಿಚ್ ಆಗಿತ್ತು, ಅದಕ್ಕೆ ಅವ್ರು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಎಲ್ಲಿದೆ ಗ್ಲಿಚ್?
ದಟ್ಸ್ ವೈ ಲಾಟ್ಸ್ ದಿ ಆಫೀಸರ್ ಹೂ ಕೇಮ್ ಲಾಟ್ಸ್ because of that Lords, and when he wanted to
This is what your lack of transparency deliberately will lead to these things.
ಅಲ್ಲ, ಸಿಡಿ ಎಲ್ಲ ಮಾಡಿಕೊಟ್ಟಿದ್ದಾರೆ. ಮುಂದೆ ಪ್ರೊಸೀಜರ್ ಇಸ್ ಫಾಲೋಡ್ Lords.
ಪ್ರೊಸೀಜರ್ ಇಸ್ ಫಾಲೋಡ್. ವೆಬ್ ಪೋರ್ಟಲ್ ಹಾಕದೆ ಹೋದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ? ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳೋದು ಆಗಿಲ್ಲ ಅಂತ
ಅಲ್ಲ.
ಈ ಕೊಟ್ಟಾಗಿದೆಯಲ್ಲ, ನೀವೇ ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಒಂದು ಪ್ಲೀಸ್ ಒಂದು ನಿಮಿಷ. ಅವರು ಈ ಪೋರ್ಟಲ್ ಬಿಟ್ಟು ಬೇರೆ ಕೊಡಕ್ ಬರೋದೇ ಇಲ್ಲ.
ಈ ಪೋರ್ಟಲ್ ಮಾತ್ರ ಕೊಡ್ಬೇಕು ಅವರು. And furthermore, section 7
Sir,
and 13.
Section 7 ಏನು?
Section 7 mandatory.
ಏನ್ mandatory?
Publication of
ಈ ಪೋರ್ಟಲ್.
ಹೌದು.
ಆಯ್ತು, ಆಮೇಲೆ
13 also. 13 they have to give work order award only through e-portal. Section 13 please.
ಆಯ್ತು, ಆಮೇಲೆ you will only help the petitioners. ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಅಷ್ಟೇ, ಯಾರು ಸಪ್ಲೈ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಅವ್ರಿಗೆ ಹೆಲ್ಪ್ ಮಾಡಬೇಕು. ಡೆಲಿಬರೇಟ್ಲಿ ವಿಲ್ ಕಮ್
ಟೆಂಡರ್ 13
ಇದರಲ್ಲಿ
ಕರೆಕ್ಟ್ ಸರ್, ಎಲ್ಲ ನೀವೇ ಮಾಡಿಸಿರೋದು, ಯಾಕೆ
ಅಲ್ಲ ಥ್ರೂ ಈ ಬೇರೆ ಮಾರ್ಗವೇ ಇಲ್ಲ ಅವರು.
ಅದು ಗೊತ್ತಿಲ್ಲ ಅಂತಲ್ಲ, ಅವ್ರಿಗೆ ಚೆನ್ನಾಗಿ ಗೊತ್ತು ಹಂಗೆ ಮಾಡ್ಬೇಕು ಅಂತ, ಬೇಕಂತ ಮಾಡ್ತಾರೆ. ಈಗ ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಅಲ್ಲೊಂದು ಸ್ಟೇ ಕೊಡ್ತಾರೆ, ವಾಶ್ ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ ನಿಮಗೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ.
ಆಂಟಿಡೇಟ್ ಹಾಕಿ ಎತ್ಕೊಂಡ್ಬಂದರು
ಅಷ್ಟೇ, ಎಲ್ಲ ಓನ್ಲಿ ಟು ಹೆಲ್ಪ್ ಯು ಮಾಡೋದು ಅಷ್ಟೇ. ಅವೆಲ್ಲ
accepting
ಇದು ಎಲ್ಲಾದ್ರಲ್ಲೂ ನೋಡ್ತಾ ಇದೀನಿ, ಎವ್ರಿವೇರ್ ಟೆಂಡರ್ ಇಸ್ ಬೀಯಿಂಗ್ ಫ್ಲೌಟೆಡ್ ಆರ್ ಲೂಟೆಡ್ ಬೈ ದೆಮ್ ಲೈಕ್ ದಿಸ್. ಏನ್ ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಇಲ್ಲ ಯಾವ್ದ್ರಲ್ಲೂ.
Even government has given time to time guidelines ಕೊಟ್ಟಿದೆ. ಖಂಡಿಸಿ ಅನಕ್ಷರ ಜಿ ಪ್ರೊಡ್ಯೂಸ್ ಅಲಾಟ್ಮೆಂಟ್
ಪಾಸ್ ಮಾಡ್ತಾ ಹೇಳಿ, ಅಫಿಡವಿಟ್ ಬೈ ದಿ ಪ್ರಿನ್ಸಿಪಲ್ ಸೆಕ್ರೆಟರಿ, ವೈ ಹಿ ಇಸ್ ನಾಟ್ ಫಾಲೋಯಿಂಗ್ ಸೆಕ್ಷನ್ 713 ಎಲ್ಲ.
ರಾಜ್ಯ ಮಟ್ಟದ ಸಂಗ್ರಹಣಾ ಪ್ರಾಧಿಕಾರ ಕಡ್ಡಾಯವಾಗಿ
ಇನ್ನ ಸೆಟ್ರೇಟ್ ಮಾಡಬೇಕು,
ಕಡ್ಡಾಯವಾಗಿ ಮಾಡಬೇಕು.
ಇನ್ನೊಂದ್ ಸರ್ತಿ ಪ್ರಾಬ್ಲಮ್ ಬರಬಾರ್ದು. ದಿ petitioner is before this court calling in question an order dated 18/7/2023 and a subsequent order dated 12/9/2024 by which the tender is sought to be awarded to the second respondent. Yes madam, which respondent?
Respondent number 5.
5.
Respondent number 5.
Proposal.
The solitary, the grounds projected by the petitioner is violation of section 7, 13 and
section 7, 13, rule 7, 8, 19, 22.
ಎಲ್ಲ ರೂಲ್ ಹೇಳ್ಬಿಟ್ರಲ್ಲ.
7, 13 sections.
Section 7 and 13 ಆಯ್ತು.
ರೂಲ್ಸ್
KDTP ಕೊಡಿ ಮೇಡಮ್.
ಕರ್ನಾಟಕ ಪಬ್ಲಿಕ್ ಟ್ರಾನ್ಸ್ಪರೆನ್ಸಿ ಆಕ್ಟ್ ಐತನ್ರಿ.
Section 7. Projects several illegalities of ಮಾಡಿ. It is his pointed submission that all the transactions with regard to the tender should take place only on the Karnataka Public Procurement Portal in terms of section 7. Section 7 reads as follows. The other illegality is violation of section 13. Section 13 deals with acceptance of tender. Tender is to be accepted and ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ ಈ ಪೋರ್ಟಲ್ ಮಾತ್ರ ಅಂತ?
The tender accepting authority shall, after following such procedure as may be prescribed, pass order accepting the tender or shall communicate the information relating to acceptance of tender together with a comparative analysis and reason for
Reads
acceptance.
as follows. Therefore, the acceptance of tender after due analysis should be on the public procurement portal as found in section 7. The learned counsel would project certain illegalities in the rules as well. Which rule is that?
Rule 22, sir.
Rule
22.
Rule 22, which is said to be violated, reads as follows. In terms of Rule 22, the evaluation of tenders and award of contract should be completed as far as possible within a period for which the tenders are held valid. In the case at hand, the tenders are valid for 90 days. Huh?
Yes.
Tenders are valid for 90 days. Therefore, the tender could not have been accepted on the 91st day even is the submission. In our rule?
7. Rule 7.
Rule 7 ಏನು?
they have to publish information
One ನಿಮಿಷ.
on e-portal.
Rule 7, section 7.
Rule 7. Rule 7 and 8.
ಒಂದು ನಿಮಿಷ.
Furthermore,
ಇದೇನು ಡಿಲೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, 7 and 8. Information to be published in the state.
Information to be published in the state tender bulletin.
7 and 8. The notice inviting tenders and the decision on tenders shall be published in the state tender bulletin in case of so and so. ನಮ್ಮ second case, the value of procurement.
ನಿಮಿಷ. Rules 4, 5, 6, 7, 8 omitted by notification. ಏನು?
ಇಲ್ಲ 7.
7,
The
4,
notice.
5, 6, 7 and 8.
ಇಲ್ಲ inviting and decisions.
Omitted by notification ಅಂತ ಇದ್ದೇನೆ.
ಸರಿ.
ಮತ್ತೆ ಯಾಕೆ ಹೇಳಿದ್ರಿ ಅದು? ಬುಕ್ ನೋಡಿಲ್ವಾ?
ಇದು mostly ಎರಡು ಕಾಣುತ್ತೆ.
ತಗೊಳ್ಳಿ.
ಅಲ್ಲ ಇದು 24.
ನೋಡ್ಬಿಡಿ. ಇದು ಕರೆಕ್ಟ್ ಇಲ್ವಾ ಅಂತ.
ಇಲ್ಲ ಅದಿರ್ಬೋದು.
ಇದು ನೋಡಿ.
ಇದು 24.
ನೋಡಿ ಸರ್. ಕೊಡಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲಿ ಅದು ಆಗಿರುತ್ತೆ.
Rule 5, 6, 7, 8. Just see that.
ಹೌದು. 19.
Omitted by notification.
Please.
ನಿಮಗೂ ಗೊತ್ತಿಲ್ವಾ?
ಇದರಲ್ಲೂ ಇಲ್ಲ. ಇದು ಹಳೆ ಬುಕ್ ಇದೆ ಅನ್ಸುತ್ತೆ.
And ಒಂದು small ಇನ್ನು ಒಂದೇ ತಿಂಗಳಿರೋದು ಟೈಮ್.
ಆಯ್ತು ನೋಡ್ತಾ.
one month.
ನೀವು ಮುಗಿಸ್ಬಿಡಿ. ಆಮೇಲೆ ಇದನ್ನ ಮುಂದೆ ಸೆಟ್ರೇಟ್ ಮಾಡ. ಎಸ್. So and so. Rule 22 ಸಾಕಷ್ಟೇ. The tender scrutiny committee ಯಾರು?
Committee. Annexure R3 page 12 committee.
ಯಾರು ಆಫೀಸರ್ಸ್ ಯಾರು?
DC
Deputy Commissioner.
page number 21 is.
The tender scrutiny committee comprises of the deputy commissioner and other officers.
9.
It is ununderstandable as to how the deputy commissioner of a district who is the chairman of the tender scrutiny committee is unaware of section 7 and 13, as the web portal even today depicts the tender to be pending. If tender has been awarded to the fifth respondent, it should have at the outset been reflected in the portal. This is the purport of this is the mandate of the statute under section 7 and 13. Therefore, the deputy commissioner, so and so, 13. There are plethora of cases filed before this court contending that the tender is issued only after the expiry of 90 days. Therefore, it is in violation of Rule 22. It again shocks as to why the tender scrutiny committee would keep quiet for 90 long days after issuance of tender and receipt of the applications and issue the work order on the 91st day to the successful tenderers. These things are to be steered clear by the chairman of this tender scrutiny committee. Therefore, the deputy commissioner
all members are not attended. Improperly constituted committee cannot decide the tender.
Therefore, the deputy commissioner shall now file an affidavit. Deputy commissioner, which district is this?
All members.
Which district is this?
This is Ballari.
The deputy commissioner of Ballari district shall file an affidavit before the court as to why violations are deliberately made in these tenders without following the mandate of section 7 and 13 or any justification for not following by the next date, list the matter on Monday in the fresh matters list. Interim order subsisting will continue till the next date.
Second matter dalli the petition was writ petition was filed. That was dismissed on 22 by following the order.
Second matter ಅಲ್ಲಿ
that this ಅದು ಹಾಕಿ ಇನ್ನೊಂದು ಸ್ಟೇಟ್ ತಗೊಂಡಿದ್ದಾರೆ. Second ಅಲ್ಲಿ.
Second matter ಕೊಡಿ, ಹೌದು ಅದು ಕೊಡಿ.
prayer
ಯಾವುದು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು?
Given last time.
First petitioner
ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಯಾವುದು?
First I given the last time copy of the order.
ಇದೆ ಅಲ್ಲ?
Please lordship's order my lords.
First petitioner
ಟ್ರೇಡಿಂಗ್ ಕಂಪನಿ ಸೇಮ್ ಇದು?
First petition ಮಾತ್ರ.
Same ಅಂತೆ. First petitioner same my lord.
First petition ಮಾತ್ರ.
ಅಶ್ವಿನಿ ಟ್ರೇಡಿಂಗ್ ಕಂಪನಿ.
ಅಲ್ಲ ರಂಗನಾಥ.
ಪ್ರೊಪ್ರೈಟರ್.
ಅಲ್ಲ ರಂಗನಾಥ ಅಸೋಸಿಯೇಟ್.
ರಂಗನಾಥ ಎಂಟರ್ಪ್ರೈಸಸ್. ಏನಾಯ್ತು ಈಗ ಅವ್ರ ಜೊತೆಗೆ ಯಾಕೆ ಸೇರಿಸಿದ್ರಿ ಇದು?
ಒಂದು ಸೆಕೆಂಡ್ ಸಮಯ.
ಡಿಸ್ಮಿಸ್ ಆಗಿರೋದು ಯಾವುದು?
ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗನೇ ಇದನ್ನ ಹಾಕಿ ಸ್ಟೇ ತಗೊಂಡಿದ್ದಾರೆ.
ಅವರು
On that ground, we'll dismiss this.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ
Cost impose ಮಾಡಿ will dismiss it.
ಅಲ್ಲ ಮೆಮೊ ಹಾಕಿದ್ದೇನೆ
ಏನ್ ಮೆಮೋ ಹಾಕಿದ್ರಿ?
ವಿಡ್ರಾವಲ್ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ
ಇವತ್ತು?
dismissal. ಇಲ್ಲ ಮೊದಲೇ ಹಾಕಿದ್ದೀನಿ.
ಯಾವತ್ತು ಹಾಕ? ಸ್ಟೇ ತಗೊಳಕ್ ಮುಂಚೆನಾ ಸ್ಟೇ
ಇಲ್ಲ
ತಗೊಂಡ
ಸ್ಟೇ ತಗೊಂಡ ಮೇಲೆ
ಯಾಕೆ sir?
ಸ್ಟೇ
ಅದ್ರ
ತಗೊಂಡ
ಬಗ್ಗೆ ಹೇಳಿದಿರಾ ಇದರಲ್ಲಿ?
ಇಲ್ಲ ಇನ್ಫ್ಯಾಕ್ಟ್ ಅವ್ರಿಗೆ ಇನ್ಫಾರ್ಮೇಶನ್
ಯಾಕೆ ಹೇಳಿಲ್ಲ?
ನನಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ.
ನಿಮ್ಗಲ್ಲ, I am not on you. These petitioners should not be allowed any indulgence.
We permitted
We will
in
dismiss it
respect
on
of
suppression.
first petitioner.
We will dismiss it on suppression of fact.
ವಿಡ್ರಾ ಮಾಡ್ತೀನಿ.
Dismiss ಆಗಿರೋದು ಯಾವ್ದು ಆರ್ಡರ್ ಇಲ್ಲ?
ಫಸ್ಟ್ ಪಿಟಿಷನರ್ ಕೊಟ್ಟಿದ್ದು
ಎಲ್ಲ ಕೊಟ್ಟೆ ಅಂತ ನೀವು ಯಾವ್ದು ಫೈಲೇ ಇರಲ್ಲ, ಯಾವ ಕೊಟ್ಟಿದ್ದು ಏನ್ ಬಿನ್ ಹಾಕ್ಬಿಡ್ತೀರಾ?
ಆರ್ಡರ್
ಮತ್ತೆ
22nd ಮಾಡಿ
22nd January 2025 ಅದು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಇದ್ರ ಪ್ರಕಾರ ಸೂರ್ಯಜೋಗುಂದ್ರ ಸಾಹೇಬ್ರು ಆರ್ಡರ್ ಪ್ರಕಾರ ಮಾಡಿದ್ದಾರೆ. ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ 3 ಮ್ಯಾಟರ್ ಮುದೋಸರ್ ಅಪೇರ್ ಆಗಿದೆ.
ಇದರಲ್ಲಿ ಏನ್ ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಸೇ ಆನ್ ದಿಸ್?
ಅಲ್ಲ ಅದು ಪೆಂಡಿಂಗ್ ಇರಬೇಕಾದ್ರೇನೆ 22nd ಆಗಿದೆ.
ಹೌದು, ಇದು ಯಾವತ್ತು ಸ್ಟೇ ಆಗಿರೋದು?
15th ಗೆ.
ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಇರ್ಲಿಲ್ವಾ?
ಅದರಲ್ಲಿ ಇತ್ತು.
ಮತ್ತೆ ವಾಟ್ ಡಿಫರೆನ್ಸ್ ಡಸ್ ಇಟ್ ಮೇಕ್?
ಅಲ್ಲ, during the pendency of this molars again this writ petition has been filed. ಅಲ್ಲಿ
ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಇತ್ತಲ್ಲ ಆಲ್ರೆಡಿ
ಇತ್ತು, ಬಟ್ ಅದು ಇನ್ನ ಡಿಸ್ಪೋಸ್ ಆಗಿಂದ ಮುಂಚೆನೆ ಹಾಕಿದ್ದಾರೆ ಇನ್ನೊಂದು ರಿಟ್.
ದಟ್ಸ್ ಆಲ್ ರೈಟ್. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲದೆ ಡಿಸ್ಮಿಸ್ ಏನಾರು ಆಗಿದ್ರೆ ಅದು ಬೇರೆ ಮಾತು. ಅದರಲ್ಲೂ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇತ್ತಲ್ಲ.
ಅಲ್ಲ, ಬಟ್ having regard to the molars the judgment on the coordinate bench that reported judgment, the lordship has considered that. Please molars, ಆ ದಾಲ್ ಕೇಸ್ ನೋಡಿದ ಮೇಲೆನೆ ಇದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ.
ಇನ್ ಆಲ್ ಫೇರ್ನೆಸ್ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದವ್ರು? ಪಿಟಿಷನರ್
ಶಿವರಾಜ್ ಮುದೋಸರ್ ಅಪಿಯರ್ ಆಗಿದೆ. They say that molars because of this judgment it may be closer ಅಂತ ಹೇಳಿದ್ರು.
Yes sir.
Insofar as first petition is concerned, petition may be dismissed please. First petitioner ಗೆ
ಅಲ್ಲ, ಬಟ್ ಕಾಂಪೋಸಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ದು, ಕಾಂಪೋಸಿಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ತಗೊಂಡ್ರದು. ಈಗ ಸಪರೇಟ್ ಮಾಡ್ಬಿಟ್ಟು ಯು ವಾಂಟ್ ಟು ವಾಶ್ ಆಫ್ ದಿ ಸಿನ್ಸ್ ಆಗಲ್ಲ. ಸಪರೇಷನ್ ಇದೆ ಅಲ್ವಾ?
they are not aware of that proceedings.
ನಿಮ್ ತಪ್ಪಲ್ಲ ಸರ್.
ಹೌದು
ಅವ್ರು ಬೇಕಂತ ಹೇಳಲ್ಲ.
ಇಲ್ಲ, ಒಂದು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮಾತ್ರ ಹಂಗೆ ರಿಪೀಟ್ ಆಗಿರೋದು. 3 ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಮಾತ್ರ ಹಂಗೆ. ಪ್ಲೀಸ್
ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಡೂ ಬೈ 2:30? ಇಲ್ದಾರೆ ಒಂದ್ ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್
ವಿಡ್ರಾ ಮಾಡ್ಬಿಡ್ತೀವಿ ಸರ್. ಅದನ್ನ ಮೆಮೊ ಹಾಕಿದ್ದೆ ಆಲ್ರೆಡಿ ವಿಡ್ರಾವಲ್ಗೆ.
2:30 ಹಾಕಿ.
ಅಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಆಲ್ರೆಡಿ
ಮೆಮೊ.
ಹಾಕಿದ್ದೀನಿ.
ಫಸ್ಟ್ ಪಿಟಿಷನರ್ಗ?
ಹೌದು ಹಾಕಿದ್ದೀನಿ.
ಸೆಕೆಂಡ್ ಪಿಟಿಷನರ್?
ಫಸ್ಟ್ ಪಿಟಿಷನರ್ ಮಾತ್ರ.
ವಿಲ್ ಸಿ 2:30. ಎಸ್, ಯಾವ್ದ್ರಲ್ಲಿ ಮೇಡಮ್?
ಸ್ವಾಮಿ
ಇಲ್ಲ ಇರ್ಲಿ, ಯಾಕೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಯ್ಯ ಮೇಡಮ್ ಹಂಗೆ ಇರ್ಲಿ. ಅದು ವಿಲ್ ಸಿ. ಐ ಹ್ಯಾವ್ ನಾಟ್ ಡಿಸ್ಪೋಸ್ ದಟ್ ಮ್ಯಾಟರ್. ಡಿಸ್ಪೋಸ್ ಏನಾಗಿಲ್ಲ ಅದು.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 ಅಂತ ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡ್ 5 ಅಂತ ಆಗ್ಬೇಕು ಆರ್ಡರ್ ದಲ್ಲಿ.
ಪ್ರಪೋಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5.
ಒನ್ ಕೈಟ್ ಸಬ್ಮಿಷನ್.
ನೆಕ್ಸ್ಟ್
ಒನ್ ಕೈಟ್ ಸಬ್ಮಿಷನ್
2:30.
ಅಲ್ಲ 24 ಗಿತ್ತಲ್ಲ, 24 27.
2:30
ಅಲ್ಲ ಇದು ಅದಲ್ಲ ಫಸ್ಟ್ ಮ್ಯಾಟರ್. ಫಸ್ಟ್ ಮ್ಯಾಟರ್
ಯಾವತ್ತು ಬೇಕು?
27 ಗೆ.
ಇಲ್ಲ 24th ಅವ್ರಿಗೆ ಅಫಿಡವಿಟ್ ಹಾಕಿ, ನಿಮಗೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗಲಿ? ಎಸ್
44 Ravi Egde, Prashant Usmani.
Request for till Monday file my statement of objections.
ಏನಿದು?
Page 189 is
What's
the
the
punishment
matter?
order. Well, 2 punishments for misconduct. One is
There is now, my lords, an interim order wherein
There is no interim order.
there is an interim order.
ಅದೇ
no. Interim order ಕೊಟ್ಟಿಲ್ಲ. Interim order ಕೊಡ್ತೀನಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದು. 20 my lord 20th January.
Monday, my lords.
Finally,
Please.
List on Friday in the fresh matters list.
45 Prashant Usmani. Girish Usmani.
Lords, sir, is auction. I am, my lords, for the auction purchaser. Sorry, for the, my lords, borrower.
Let's borrow. Auction notification has been challenged. Auction has not taken
Property
place.
stay ಮಾಡಿದ್ದೀವಿ. One
Please,
property
one
Please, my
property.
lords. Auction has not been successful, my lords.
As far
That
as
say prayer number 1 does not survive cause consideration. In respect of prayer number 2, my lords, we will
my lords,
consider
I'll
and
just,
pass.
my lords, narrate few facts of this case. 2015, my lords, the firm was formed, which was, my lords, a borrower. I was one of the partners. There are 2 partners. 2017, I retired. The other partner, the existing partner, my lords, he said to the bank that he's gave an undertaking. He said that he will give a separate collateral and the property of the petitioner has to be released. He did not give a separate collateral. but this was informed to the bank. A reconstitution deed was done. Another partner, my lords, came into this. And now, my lords, please. Now, my lords, under section that
Auction has not taken place.
Not taken.
The date has spent itself. This will not survive, in fact.
this will not survive.
We'll
Only
reserve liberty if they again do the same thing to knock at the doors of this court.
because under section 32, subsection 2, my lords, I can be discharged from the liability. May I just read for a moment?
Give a representation.
But that I have done that. I have several occasions, my lords, I have done that.
Will they do that? Will they ever do that?
And there is,
Charging liability on the guarantor, they will never do.
if there is, my lords, what the section
There
says is,
is, but they will never excise that.
It's, my lords, the real facts are that, my lords,
That
there is a,
will- And if a direction to that effect is given, it is dangerous.
that's
Because both the guarantor and the borrower are on the same
I would, my lords,
shoes.
request just one, my lords.
and there is a
1
internal
crore
difference
17
between them.
lakhs, my lords, is the loan amount. The plant and machinery itself is 2 crores, apart from these house properties. In fact, these,
ಇದು ಬೇಕಾದ್ರೆ ಪೆಂಡಿಂಗ್ ಇಡ್ಬೇಕು ಅಂದ್ರೆ ಇಡ್ತೀವಿ, ತೊಂದರೆ ಇಲ್ಲ.
let-
ಅವ್ರು ಇನ್ನೊಂದು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ
then, please.
ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ they will do the same thing.
My lords,
The Learned Council,
my lords,
so and so.
my lords, my submission is that, my lords, there is an internal difference between the borrower and the guarantor, my lords.
ತೊಂದ್ರೆ ಇಲ್ಲ, ನೀವು
So,
ಮಾಡ್ಕೊಳ್ಳಿ.
for that reason, my lords,
Let's-
my lords, let the
After
representation,
2 weeks, interim order subsisting would continue next date.
my lords, instead of that, my lords, we will consider the request, my lords, and will take necessary appropriate action, my lords. But, my lords, if it is kept pending, my lords,
ಏನಾಗಲ್ಲ, ಆ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ಯು ಕಾಂಟ್ ಪುಟ್ ಇಟ್ ಟು ಆಕ್ಷನ್. ಇಲ್ಲಾರ ಮತ್ತೆ ಇದನ್ನೇ ಮಾಡ್ತೀರಾ ಅವಾಗ 13 ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ. Yes.
better, my lords, only one request, my lords. We will consider, my lords, we will consider the request.
My applications are there. They, my lords, pending this petition, my lords, they can still consider and
Consider and report back. Yes.
And, my lords, in respect of the property number 1, my lords, let the bank may be permitted to.
2.
proceed. 2,
Property number 2.
I have not restricted you at all. ನಿಮ್ಗೆ ಏನ್ ಬೇಕು?
please, my lords.
46, Nagangoda and Patil, MG Kulkarni.
My lord, so matter pertaining to
Your
leave encashment, my lord.
So encashment of leave by the dismissed employee, lordship.
Dismissed employer.
Yes.
Yes. Yes, my lord. I have produced a decision, my lord. As
Will
per
pass
that,
orders. Arguments ಆಗಿದೆಯಲ್ಲ, you want to make
ಇಲ್ಲಿ
some.
only partly hear ಮಾಡಿದ್ರೆ,
ಹಾ?
partly hear ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ.
ಈಗ fully ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Only ನನ್ನ draw kind
ಅಲ್ಲ,
attention.
anything, any
Only thing,
submission you want.
only thing, lordship. I draw your attention to regulation 67,
Correct.
opening words.
Hmm.
All
Lapse of leave.
Lapse of leave. And moreover, if he ceases to be in the service
Correct.
by any mode, maybe termination also, by on account of commission of certain frauds or something of that sort. In such a situation, so only 3 situations have been contemplated by regulation 67. One is death, one is retirement. Now by virtue of court decisions, the compulsory retirement has been included. One more is retrenchment. They didn't incorporate this dismissal. It's ultimately stigma to the employee. And the decision which is relied upon by my learned friend is this writ petition number 1347 of 216, Ashok Manjappa Potpale.
Ashok?
Manjappa Potpale.
ಯಾವ್ದು ಅದು ಅಶೋಕ್?
I produced last time, my lord.
ಬಾಂಬೆ?
Yes, my lord.
ಏನಾಗಿದೆ ಇದು?
There are 7 may kindly be seen, lordship, page number 6.
ಅದು ಜಿತೇಂದ್ರ ಕುಮಾರ್ ಶ್ರೀವಾತ್ಸ.
In this also, it pertains to pension, your lordship. Can we equate the pension with the encashment of leave?
We will not rely on this at all.
Absolutely.
There are
And-
other ways to allow the petition.
Even
Objection.
there are many
My
decisions held
objection
by
may kindly
different
be
high
taken on
courts, my
record.
lord. Even they are in favor of employee, my lord.
Is before this court calling in question an order dated 13/12/2017 and an order endorsement dated 4/10/2024 by which the bank rejects the payment of encashment of privilege leave accrued to the petitioner throughout his service. Heard so and so. Facts in brief germane are as follows. The petitioner joins the service of the respondent Karnataka Gramina Bank, hereinafter referred to as the bank for short, and works as works as an assistant manager in various branches of the bank. It transpires on 31/3/2012. The bank initiates disciplinary proceedings against the petitioner alleging certain misconduct by issuance of a charge sheet. The inquiry conducted against the petitioner leads to imposition of penalty of dismissal from service with effect from 19/12/2014. The petitioner represents to the bank seeking payment of his terminal benefits with particular reference to leave encashment. The said leave encashment that was accrued to the during the service of the petitioner for about 220 days is denied on the ground that the petitioner has been dismissed from service on account of misconduct, and therefore the regulations would not permit payment of leave encashment to an employee who has been dismissed from service. It is therefore the petitioner is at the doors of this court in the subject petition. The learned counsel appearing for the petitioner submits that section 67 cannot be invoked to deny the leave encashment of the petitioner, which is his right in terms of the regulations, and would seek to place reliance upon a judgment rendered by the High Court of Bombay in writ petition 1347 of 2016 to buttress his submission. Per contra, the learned counsel representing the bank could take this court through regulations, again with particular reference to regulation 67, to contend that regulation 67 deals with lapse of leave. If the employee ceases to be in employment of the bank by any mode, he would not be entitled to payment of privilege leave or leave encashment, as the case would be, is his emphatic submission. He would submit that since the petitioner has incurred since the petitioner was proceeded departmentally and a penalty of dismissal from service is imposed upon him, there can be no question of payment of privilege leave to the petitioner. I have given my so and so. The aforenarrated facts are not in dispute. Idya Jitendra Kumar Srivastava ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, it's held by Supreme Court, my lord.
Ashok ಎರಡೆರಡು ಕೊಟ್ಟಿದ್ದೀರಾ? Yes. So and so. The aforenarrated facts are not in dispute. The issue now lies in a narrow compass. The issue is whether an employee who is dismissed from service is entitled to encashment of privilege leave, notwithstanding the dismissal being on account of certain misconduct. Therefore, it becomes a plain interpretation of the regulations of the bank. The regulations, i.e. Pragati Grameen Bank Officer and Employee Service Regulations 2013, deals with the said circumstance. Regulation 61 and 67 are germane to be noticed. Regulation 61 deals with privilege leave. It reads as follows. An officer or employee of the bank is eligible for privilege leave computed in the manner that is depicted in Regulation 61. Therefore, Regulation 61 forms a right on the part of an employee to get the privilege leave at the maximum of 220 days. That can be taken away. The other regulation is Regulation 67, which deals with lapse of leave. Regulation 67 observes that all leave shall lapse on the death of an officer or employee, or if he ceases to be in the service of the bank. The Regulation 67 Regulation 67 does not mandate that if an employee is dismissed from service, his privilege leave that is accrued under Section 61 would be taken away, or that would be the effect that is axiomatic upon the ceasing of an employee from the service of the bank, be it dismissal from service, removal from service, compulsory retirement, or otherwise. There is no indication of that kind in Regulation 67. The interpretation of Regulation 67, qua the the right under regulation 61 of an employee to get the privilege leave need not detain this court for long or delve deep into the matter. The High Court of Bombay and High Court of Madhya Pradesh have both considered, division benches of High Court of Bombay and High Court of Madhya Pradesh have both considered this issue and held that an employee's right to get privilege leave is akin to a right to property under Article 300A of the Constitution of India, and therefore such right cannot be taken away unless the statute mandates or permits. Therefore, there is no substance in the contention of the learned counsel for the respondent that that regulation 67 could be pressed into service to take away the right of privilege leave accrued to an employee, albeit him ceasing to be an employee on account of a penalty being imposed in the case at hand, dismissal from service. The division bench of Bombay, High Court of Bombay, in a judgment reported in 2024 SCC Online Bombay 1253 has held as follows. A little earlier to the said judgment, the division bench of Madhya Pradesh High Court, in a judgment reported in 2023 1 MPLJ 209 has held as follows. Both these judgments, one common stream that runs through both these judgments is the right of an employee to get privilege leave under section 61, unless section 67 is specific that regulation the right under section 61 can be taken away. It cannot be taken away. I am in complete agreement with what the division bench of both the high courts have held, and would hasten to add that the right of an employee under section 61 of the regulations cannot be taken away by regulation 67, which deals with lapse of leave, unless there is a specific indication in regulation 67 that on account of dismissal or removal or compulsory retirement or any kind of cessation of service would result in privilege leave being taken away. In that light, the petition deserves to succeed, and entitlement of the petitioner to the grant of privilege leave to his credit. For the aforesaid reasons, the following order: allowed quashed. The petitioner is held entitled to privilege leave at 220 days that is accrued to his benefit throughout his service. The same shall be paid by the bank within 2 months.
With the interest.
Within 2 months from the date of receipt of the copy of the order. Other copy
2 months.
2 months. In the event the payment is not made within 2 months, the petitioner shall become entitled to interest at 6% per annum from the date it fell due till the date the amount reaches the doors of the petitioner, ordered accordingly. Yes.
47, Girish V. Bhatt, AP Murali.
Please, my lords. This petition challenging the order of termination, my lords, on account of a conviction.
That particular conviction was stayed by.
The conviction is also stayed.
I filed my objections, my lord.
Stay ಆಗ್ಬಿಟ್ಟಿದೆಲ್ಲ ಏನ್ ಮಾಡೋದು?
Yes, stay against my lord. ನಂದೇನಿದಿಲ್ಲ ಅದರಲ್ಲಿ
ವಾಪಸ್
ಏನಿದಿಲ್ಲ.
ತಗೋಬೇಕಲ್ಲ ಮತ್ತೆ?
Yes, my lord. Only thing is that now he has been terminated from service. Quarters ನಾವೇನು ಬಿಡಿಸಿಲ್ಲ. Quarters ನಲ್ಲಿ ಇದ್ದಾರೆ, entry motor ಇದೆ.
ಕ್ವಾರ್ಟರ್ಸ್ ಗೂ ಸರ್ವಿಸ್ ಗೂ ಸಂಬಂಧ ಇದೆ.
ಅಲ್ಲ ಸಂಬಂಧ ಇಲ್ಲ, ಅದರಲ್ಲಿ ಇದ್ದಾನೆ. ಈಗೇನಿದಲ್ಲ, let him face another fresh enquiry, my lord.
ಫ್ರೆಶ್ ಎನ್ಕ್ವೈರಿ.
ಅವಾಗ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದಾಗ ಅದು ಆರ್ಡರ್ ಇದ್ದಿರ್ಲಿಲ್ಲ ಮೇಲೆ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದಾಗ ಆರ್ಡರ್
ಯಾವ ಕಾರಣಕ್ಕೆ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದ್ದು?
ಪರ್ಟಿಕ್ಯುಲರ್ ಕನ್ವಿಕ್ಷನ್
ನೀವೇನ್ ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಿಲ್ಲ.
ಸಪರೇಟ್ ಎನ್ಕ್ವೈರಿ ನಾವೇನು ಮಾಡಿಲ್ಲ.
ಬೇಕಾಗೂ ಇಲ್ಲ.
ಬೇಕಾಗುದು ಮೇಲೆ
he will incur disability the moment he is convicted. Conviction is stayed. So put him back.
ಅಲ್ಲ, let him now. This was not before the court. This was not before the authority. Stay ಆಗಿದ್ದು.
Not necessary. Now the authority.
My submission may kindly be noted.
Now the authority knows.
Yes. No.
Conviction stay ಆಗಿರೋದ್ರಿಂದ.
Yes. ನಾನು ಸಬ್ಮಿಷನ್ ನೋಡ್ಕೊಂಡು ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು. ನಾನೇ ನಿಲ್ಲ ಅನ್ನೋದಿಲ್ಲ.
ಅದೇ ಒಂದೂವರೆ ಊಟ ಆದ್ಮೇಲೆ ಮಾಡ್ತೀನಿ.
Yes, please. Yes, please. ಅಷ್ಟೇ.
48, BD Narasimhan.
ಊಟ ಆದ್ಮೇಲೆ ಅಂದ್ರೆ
One submission, my lord.
2:30 ಅಂದ್ರೆ.
One submission, my lord. Seal number 200, I filed withdrawal, memo for withdrawal. I filed 100 files, my lord.
ಕವಿತಾ madam, 200 in terms of the memo.
Seal number 200. my lord.
With your lordship's permission, matter at 2:30.
Usmani ಎಲ್ಲಿದೆ? 2:30 ಗೆ Ravi Hegde. 2:30 ಗೆ take that second list. Covered matters, we'll close it.
My lord, serial number 36, my lord. It was urgent, my lord.
Urgent?
Urgent.
Urgent. ಯಾಕೆ ಏನಾಯ್ತು?
My feet was in other.
Your feet?
My lord. It is covered, my lords, regarding physical instructor, my lords.
ಇಲ್ಲ ಇಲ್ಲ, ಅದು ಹೆಬ್ಬಳ್ಳಿ ಅವ್ರದಲ್ವಾ? Not covered. Statute is sent and governor is ಆಮೇಲೆ ಮಾಡಿ.
With your lordship's permission, my lord.
I know.
Matter at 2:30, my lord.
Yes, Chetna madam.
Serial number 52, your lordship. Mandamus last time it.
Adjourn ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ, mandamus ಇದೆ. Mandamus ಇದೆ. Just
ಆಯ್ತು, ಇದು ತಗೊಂತೀನಿ.
please.
My lord, matter to be taken at 2:30, my lord.
It is 1:30, sir.
2:30 ಗೆ matter is required to be taken.
ಈಗ ಮೆಮೊ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Because I got it filed and I got the number just now.
So
the order questioned is on the 15th, my lord. The appointment.
Tomorrow.
My lord, serial number 205, please.
He is likely to take charge today or tomorrow morning. In that case, it becomes faith a complaint. I will not be having any.
ಆಯ್ತು ಕೊಡಿ ನೋಡಿ.
My lord, serial number 205, please.
205.
All objections are complied with, my lord.
That will
So I
cease.
pray-
Wait.
My lord, serial number 86, covered matter, tax matter.
Covered matter.
Covered. There are about 70 cases which the.
Respondent is saying that it is covered?
Yes, he is saying that.
Serial number?
86.
One ನಿಮಿಷ.
And also there are two more at.
70 cases ಅಂದ್ರೆ?
Sorry, my lords?
86.
86. It's a service tax issue where the demand was based on income tax data.
ಆಯ್ತು, we'll take it.
Grateful.
I can go.
My lord, serial number 205, please. 205, my lord.
Wait, sir. Madhyana. Yes.
Serial
Please,
number
please.
162, freedom fighter pension matter, my lords, 95-year-old petitioner. Her, it is covered by your lordship's judgment, Nagbhushan Rao.
Before I raise.
Serial number 68, your lordship.
Adjournment.
I request for tomorrow, your lordship.
Madam,
I have serious objections, my lords, for.
Tomorrow ಇಲ್ಲ madam.
68, I have serious objections, my lords, for adjournment.
Which 68?
68, my friend is mentioning. There's an interim order in operation.
Vacating stage.
I am.
68, then wait, madam.
The very petition itself is not maintainable.
Objections ಇದ್ರೆ ಇಲ್ಲ.
My lord, 205, I pray for, to kindly list it on 24th, my place.
Mention.
Objections are complied with, my lord.